So anyhow, to that end, Mr. Aurora, I believe you were taking up the Supremacy Clause issue. All right, the floor is yours.
Shock the court and say we are going to do a PowerPoint
All
today,
right, here
but
we
I'll try
go.
not to read the PowerPoint and give you something specific. So just let me know when you're ready, Your Honor.
No, whenever you're ready.
All right, so the Supremacy Clause, the reason I filed that brief is obviously we're all sort of learning about these things. I don't even remember learning about it in law school, frankly, to be honest, until I got involved in this case about 6-7 weeks ago. So what we know from the Supremacy Clause is if state and federal law conflict, then federal law displaces or preempts the state law because of the Supremacy Clause. So if we go to my next slide, the reason I brought up the Supremacy Clause in this issue is it seems like in this case, there's just a fundamental misunderstanding in some of the pleadings that I've read from the state. All I ever see is the governor certified the panel that was Democratic in this case, and therefore anything else that was done, i.e. a second slate of electors, fake electors, alternate electors, are all fraudulent, fake, and that's what all the substantive counts talk about. And that exactly is a fundamental misunderstanding by the government, because the governor certifying it is almost a non sequitur. It essentially means nothing under the ECA. And even in our own code section that I've cited there, Your Honor, it talks about once the governor certifies the election initially, just a few days after the actual voting takes place, only then can the challenges to the election start. And if we read the ECA, the issue with the governor certifying it is when all the votes get to Congress, and the two houses of Congress cannot agree, then and only then does the governor's certification break the tie, if that's the case. Otherwise, the governor's certification is not the end all, it's not the be all, because lawsuits don't even start until after the certifications. All right, so where does that lead us then, Your Honor? What we've got is Article 2 and Clause 1, and then the ECA, the Electoral Count Act, again, it's something I've had to learn about in the last couple of months, specifically give a very limited power to the state. It's not like we all think, because most people didn't even know what the Electoral College essentially was, how it worked. It's all federal. So if we go to the next slide, what we talk about under the Supremacy Clause is what happens if it's all federal. And so that's where the preemption doctrine comes in. And then there's 3 types of preemption, being structural, field, and conflict. In our case, I think all 3 would arguably apply. Structural means basically the exclusive authority to handle something is just with the federal government. And I cited Cook v. Gray-like, and I provided, I think, copies to everybody this morning once I finished it up. In Gray-like, it was the state of Missouri was trying to enforce term limits to their Congress people that were leaving the state of Missouri, and they said, you can't do that, that's exclusively federal. And what you'll see in the future slides is the actual voting process and how the presidential ballots get sent to Congress is an exclusively federal process. We then have field preemption as far as that goes. And that basically means if Congress has got so much law or so much explanation out there that there's no room for the states to supplement it, and that federal law is so dominant. And so once I cite all the Georgia statutes, the court will see that the federal interest in the voting after what we call the safe harbor date becomes field preemption. And I'll talk about that in just a moment. And then I cited English versus General Electric here to the court. And that's a North Carolina case where a whistleblower was alleging safety violations at a nuclear power plant. And that case was very interesting in that what is purely federal, because nuclear power is regulated by the feds, versus what a state civil claim could be. And it was an interesting talk just to get some background. And we finally have conflict preemption, where the 2 sets of laws conflict with one another as far as this election goes. And so compliance is impossible. And we're saying in this case, it's impossible because if the second slate of Republican electors vote on what's going on and then send the ballots, that's essentially what all the predicate acts and a lot of the substantive acts in this case are saying are false, in that when they voted, they were being fake electors or fake government officials. When they signed it, that was a forgery. And when they submitted it, it was a false document that was being presented. And the state is it's just a fundamental misunderstanding of what the rules are here. So the state is trying to usurp the Congress's authority in here. And so I've cited Nelson v. Loney. It's back from 1890, but the reason that's important is it was a Virginia case where there was a dispute as to which congressperson from Virginia would actually go to Washington. And so Mr. Loney ended up testifying, and the state charged him with perjury, sort of like what we have here. And they said that is a purely federal matter. And even though it's from 1890, it has been reversed. And the state will say, Manny, you can't cite anything, can't do. This is all novel, Your Honor. We all know that this is all novel, so we can call it, there's no case law, whatnot. We're sort of figuring it out as we go, because this is a case of first impression. Under Pennsylvania v. Nelson, in that case, which is somewhat familiar to us, if you want to think about it that way, it's a member of the Communist Party that's trying to overthrow the government in Pennsylvania. And in that case, he was charged with sedition under the Pennsylvania laws, and he was convicted. The Supreme Court reversed it, saying sedition and all those types of things are purely federal matters and they don't apply. With regards to Loney, if I could approach you, Your Honor, just the opening sentence in Loney just basically tells you, as far as the Supremacy Clause, what is supposed to happen. And then as you read through it, you'll get a lot more of the details. And then at the end, where the holding is, it basically says the feds get to do these purely federal matters, they get to control, and the state convictions can't stand. So with regards to, I've already mentioned that the governor issue is that the Georgia law itself recognizes alternate slates of electors. So if we look at 21-2499B, it specifically talks about the Secretary of State getting each slate of presidential electors in subsection B. It's sort of buried in there, and you have to actually read all the rules in the law to sort of understand it. And that is presented to the governor, and the governor can certify anything. So in this case, the governor could have said, I agree with the voter fraud issues, and I'm going to send up the Republican ballots. Well, the Democrats get to send it up too, and it's somewhat parallel to Hawaii and some of the other early 1800s cases. But Georgia law itself, in its own language, talks about a second slate of electors, and therefore they are not per se illegal as the state has charged in this case. I would also ask the court to recognize under OCGA 21-2-180, if Judge McAfee and Manny Aurora decided we're going to form a party and we get 1% of the vote in the state of Georgia, you and I and 14 of our friends, Your Honor, could go to the Capitol, follow the rules as to how you're supposed to vote, and submit our own slate of electors under Georgia law. And that's 21-2-180. As long as we have 1%, we're a legitimate party at that point, and we have the right to vote. And that's something that the government has, I'm hoping they understand. Next slide. And so what I want the court to focus in on is Georgia law is very limited, as I said in the beginning. So what they can tell you essentially is where it says meet vote, that's where can the presidential electors vote. And it says specifically in the statute 21-2-11, as directed by Congress. And Congress says you have to go to the Capitol and do it at noon and all those kinds of things. And that's what we adopted as a state under 21-2-11. It also talks about how you can nominate a presidential elector under the code section and how you qualify a presidential elector, how to fill vacancies under state law, and then the ascertainment that the governor signs off on. But it never allows the state to have the power to control how they vote and then how those votes are submitted up to Congress. Those are specifically Electoral Count Act functions. And the important thing is the Electoral Count Act, essentially, Your Honor, is 2 pages. The first page is 258 words and a massive run-on sentence, which nobody seems to understand. And I want the court to recognize that because of the confusion and sort of the lack of any history out there except for some learned treatises, we changed the Electoral Count Act in 2022 specifically to avoid what happened here in 2020. And those are some of the eventual briefs and things like that that Mr. Chesbrough wrote that we'll talk about under the First Amendment issue. Next slide, please. So what we have to understand is the governor's certification isn't a final decision. That's just the start of the process. And so 21-2-524A basically says you can file challenges within 5 days of the certification. That's when the party essentially gets going. That's not the end. And so I've also cited another statute that sort of talks about that tangentially. Next slide, please. And so when I say that we can have multiple sets of electors, we're using Governor Kemp's own words here from November, where he said, earlier today, Secretary Raffensperger presented the certified results of the 2020 general election to my office. State law now requires the governor's office to formalize the certification, which then paves the way for the campaign to pursue other legal options and a separate recount if they all choose. So the governor's certification is just the start of the process. Whether he certifies it once or twice, like he did in this case, we then get to challenge those certifications if we choose to in court. And as I said with the other statutes, we have a right, if we have 1% of the vote, to present our own slate of electors. That is not illegal and it's not a forgery. And that's just a fundamental misunderstanding that's been argued at the federal courts down to your honor as far as preemption goes. Next slide, please. And so the one real United States Supreme Court case that I could sort of find that talks about elections is U.S. Term Limits, Inc. versus Thornton, and I'll let the court sort of review it. We've sort of cited it in our brief as well, and I don't need to rehash all this stuff, but it just again says the state is very limited in what it can do for presidential elections. And I think I cited you the half dozen statutes that talk about that. Next slide. So then what is the Electoral Count Act of 1887? And again, understand the language has dramatically changed between 2020 and 2022 when they amended it. So for about 130 years, it was a 2-page document would run on one giant run-on sentence as far as that goes. And we fixed that in 2022. So the key takeaway is it's all been codified under Title III. And so the safe harbor date, which this term I've used before, means it's 6 days prior to the electors meeting, and which in this year would have been December 8th of 2020. And that's codified under 3 USC 5. And again, I put 2020 next to all of it because if you Westlaw search it now, the new will come up and you'll be like, Manning, what are you talking about? And then the final judicial determination of the controversies or the lawsuits have to be done by the safe harbor date. That's sort of what the ECA says in its plain text. And then the meeting and the voting via Constitution and the ECA is basically the first Monday after the second Wednesday or whatever they used to say. But in our case, it was December 14th of 2020. And so nationwide, everybody at noon would have done that. And that's under subsection 7 of Title III. And finally, the counting date is that Congress has to start the count on the 6th, and it can go as long as they want as they're in session under subsection 15. And once Congress has started, they make the final decisions. If there's open lawsuits pending, the law will say that they get to decide what the right answer is. And again, if one house says X, one house says Y, then the governor's certification, whoever the governor chooses to certify, and there's no requirement that they take the majority person or not, the governor can have a wild hair and do whatever they want. Only then does the certification come into play. Otherwise, it's just sort of like arraignment in our case. It's the starting point of when everything happens. So let's talk a little bit more about the provisions. At least 5 different times in the text of the ECA, they talk about we anticipate multiple slates of electors being presented to Congress. It says it over and over and over again in a 2-page document. I found at least 5 places specifically. It's out there and it's specifically codified under section 15 of Title III. Next slide, please. So the issue becomes, if you are accused of being a second slate of electors, which is then being a false government official, and if you sign the vote, that's false. If you submit the vote, that's false. It makes compliance with state and federal law impossible, and that's where conflict comes in. The ECA and the state of Georgia recognize multiple presidential elector ballots can be generated. And again, if we just had 1%, the McAfee Aurora ticket could generate its own set of electors. Congress can throw it in the garbage when it gets there, but it doesn't make it illegal. And so essentially the state is usurping Congress's authority in order to do this under all but limited case law that we have. And the last slide, please. So aside from this issue, I would also ask the court to consider like the 10th Amendment and the 14th Amendment. One of the questions that people in my office had asked me, well, if everything's preempted, why can't state law control anything as far as, you're violating state laws? The laws in this case, being it the fraud, the submitting false ballots, false voting, are purely done at a federal level. They're not necessarily a violation of state law in this case. That's why preemption is important. This isn't murder. This isn't aggravated assault or rape or robbery, which is purely state out there. So if you compare the 10th Amendment with the federalism as to what they've given us, we get to control murder and all these other street level crimes. But under the 14th Amendment with regards to the ECA, and it tells you how to vote, how to do this, what to submit, what ballot goes up, and how it gets voted on, it's purely federal at this point. It is not a state issue because you're committing a federal act by doing all this stuff. And therefore, all the preemption doctrines apply in this case, be it conflict, be it field because it's pervasive on the government side, or if it's purely structural, which means it's overwhelming. I think all three apply and the court can hang its hats on all of it. It's just a fundamental misunderstanding when I read the government's pleadings and they talk about, well, the governor of the state of Georgia certified this and that's it. And that's just not it. Even if he certified it a second time, which he did in this case, lawsuits were pending at the time, and it was up to Congress to decide on January 6th who won or not. And the certification of the governor is only the tiebreaker as far as that goes. And so I don't see a way around the ECA. I don't mean to be flip about this, but it's relatively clear. Thank you, Your Honor.
Oh, well, don't run away just yet. Just want to kind of clarify a few things. So are you basically saying that, understanding that there are several other reasons why you think the indictment is defective or the prosecution, but are you saying that the Department of Justice could have put forward this indictment and this wouldn't be a claim for you to pursue?
Right. We are saying under the ECA, once the safe harbor date goes down, if you read this ECA and the Title III, as I've cited, the power goes back to the feds. They've given us power to have everything done by the safe harbor date. That's why the governor certifies it then. That's why in Bush versus Gore, the lawsuits had to be done by, in our case, being January 8th. I don't know what it was back in 2000, and those cases talk about it. And so the authority in this case is delegated from the federal folks. It's not state-generated authority. You can't vote for president as a state law issue. The feds say under the ECA, this is what the states can do. And the states have listed a few other things, as I pointed out, as to what you can do. And I've cited to all that. That's all procedural. How they vote, where the votes go, who signs what has to be notarized, certified, isn't a state issue. This isn't common law type stuff. This is pure federalism. The feds haven't given up that authority as far as it goes when you read it in conjunction with the 10th Amendment. And so once the safe harbor date comes, the power reverts back to the federal authorities because that's our cutoff date. On the 8th, everything's got to be done. And then on the 14th nationwide, the electors meet and vote how they will.
And then bringing your claim more in line with what we've seen in other Supremacy Clause opinions, it seems to me that you're saying this is an implied preemption versus an express, or I think you were saying all of the above. I just want to clarify that.
Right. I think I'm saying all of the above because if you look at the ECA as it is, once the 8th of December came and went in 2020, Your Honor, my position would be structural because they've taken the power back. The delegation, the limited delegation that I've cited to you is taken back. If the court doesn't like that one, then there's the pervasiveness because the 1890 case going back where they're talking about congressional seats, they also say the perjured person in the 1890 case couldn't be prosecuted by the state. They reversed his conviction. It should be a federal case because you're talking about Congress people being elected and who actually won that election.
But if it was express, there would have to be a specific section in here that we could point to that say this is where the state is prevented from getting into this, right?
I don't think there's anything I can point to in the ECA that says it's express. It's essentially, it's 2 pages. So I'm saying if you look at the implication and you look at the federal codes under Title III that goes, and then you look at what Georgia's done. There's nothing in Georgia that says you have to do it X, Y, and Z way. I've cited the 5 statutes that talk about how the electors, how they can actually be nominated. That's essentially what we do. We do some procedural things, but there's nothing in there that says this is how you vote, this is where you send it, this is what you do. And so those are all learning experiences because I didn't even know what Title 21 in the state book was versus the federal book. And so I think it's implied. I can't say express, but the law de facto makes it an express issue because there's nothing under the state statutes that talk about these electors, and everything we have, Your Honor, allows for a second set of electors from the ECA to even Georgia, the code sections. It's just buried in there under that title I cited you.
So I think in your reply, you use a phrase here that essentially anything after the safe harbor deadline, any conduct is beyond the state's purview. So is your position then that anything involving the ECA cannot be charged by the state after the safe harbor date?
If it stays within the safe, okay. If I'm going around shooting people because I want to protect, I can't claim the ECA because that specific crime hasn't been delegated down to me as far as that goes. The ECA delegates the ability to how vote from the electors. So what we're being charged with is the electors got together and took an oath. That's illegal because now they're pretending to be government officers. There's a debate whether presidential electors are federal or not, as we sort of heard in federal court as far as the removal proceedings go. I don't want to get into that. Then they actually voted, which they're saying that's an illegal vote, and they signed their name, which is forgery. And then they presented it to the governor, which was a false swearing as far as that goes. All that is the process that the ECA says we have to do. There's nothing in Georgia law that contradicts it. And that's why I'm saying for that limited purpose, I'm not being crazy and saying if I start beating women and doing all that stuff out there and to try to get the ECA out there, I'm covered by all of it. It's just specific things that are related to
anything to do with electors after 12-8, state has to say hands off.
According to the ECA, that's what you have to do because none of this stuff is false. The problem is before we even get there, if you can have a second set of electors, how can it be illegal? The state statute itself says 1%. If the McAfee Aurora ticket has 1%, we can submit our own electors. It's up to Congress to do it. You and I submitting our own electors, if we meet the definition of what a political party is in our state and we get the added
What if we don't meet that definition? We're the only two people in our party, but we're claiming that we got 1% and we submit it and we say we're entitled to be part of that slate.
Well,
we do something that doesn't fall in line with the way we were supposed to do it.
Right, but the law doesn't allow that, then it would never go anywhere because what we're doing is inherently violating both the state law that says how the electors get picked, because if we're not at 1%, which is what the state requires, we can't be a party. So at that point, technically, we've committed a state crime. But if we meet the criteria to be a party, then we can forward the electors. And that's why the ECA at least 5 different times says.
So let me jump on that because it says, assuming you've added a fact that no, we did meet that 1%, right?
Sure.
So essentially your argument is, as I take it, is that as a matter of law, that the indictment should be dismissed. I'm getting held up procedurally here,
Sure.
Where you're assuming certain facts that we haven't established yet in order to make the claim. It seems to me that these arguments might be procedurally, just by the way the process is designed, could be better received at the point of a directed verdict. But a pretrial phase, I'm just, and this same issue is going to come up in the First Amendment claim as well.
Sure.
When you're adding facts like we just talked about, how can we determine that in a pretrial
Well, I guess
situation?
I'm not sure what facts necessarily I'm adding, Your Honor. What we have the indictment, and it says the second slate of electors are de facto illegal. When they nominated themselves, that was illegal. When they voted, it was illegal. When they signed their names, it was illegal. And when they sent it up to go to Congress, it was illegal. That's right, square, dead fact on the ECA. There's nothing I'm adding to this. This isn't a speaking demurrer, whatever the government wants to argue. This is the indictment. And what I'm saying is you have the case law. So technically, if you look at the indictment, I say guilty, you can say it's all this, but you have to read the ECA in context of this statute because the ECA says you can't do it as long as I stick within the 4 corners of the election process itself. Not that I went out and murdered somebody or tried to bribe people or do any of that kind of stuff. That's why I've cited the very limited cases that are out there. But the most important thing is Georgia law specifically tells you this is all Georgia can do. And there's nothing in the Georgia code that says after December 8th, we had the power. And so if we look at the Bush v. Gore thing, that's sort of where it all got stuck back in 2000. They'd passed the January 6th deadline. The lawsuits were out there, but the Supreme Court specifically said you can't keep recounting after January 6th, I think in that case December 6th of that case back in 2000, because you'd be violating state law because the state doesn't have the authority to do any of that stuff. And that's why the recounts never happened in Florida past the safe harbor date. It's incredibly confusing. There's essentially 2 or 3 cases on this whole thing, but it's the lack of law, at least in Georgia, that is what controls here. And I think procedurally, you have a right to say they stayed within this. If we did one of the crimes alleged outside what you think is a valid election process, then it stays. Absolutely.
But also last point I have for you is you say there's the safe harbor date and everything before that would be okay. If I remember correctly, every count against Mr. Chesbro has a range of the 6th to the 14th, I believe. So how are we supposed to know, according to the language of the indictment itself, whether every one of these satisfies your pre-safe harbor requirement?
Well, the writing of the brief I can take up with the First Amendment and some of the other RICO issues that we've talked about, as far as you'll have to decide, is it valid legal advice, much like the federal court in Eastman said it was valid legal advice, being the November 18th memo. But in the indictment itself, I think, could I just pull the indictment here for a second?
I'm just saying, as indicted, it has this range of dates, some of which fall before the safe harbor deadline that you said is this line in the sand, right?
Right, but with regards to the electors in our case, at least on the substantive counts, we're 9, 11, 13, 15, 17, and 19. I think those 6 or 7. Everything's on the 14th of December as far as that goes with regards to voting. If we then go into the RICO overt acts, almost everything.
Well, no, based on what? Because it talks about we're charging a conspiracy, for example, in count 9, and the range is that a conspiracy formed between the 6th and the 14th. So how can we just say that everything happened on the 14th?
Okay, I'm saying everything happened on the 14th by reading the overt acts, non-predicate acts that we're charged with, and the specific substantive counts. So even if we want to quibble or disagree about the RICO thing, because there's something that says on the 6th, there's substantive counts, at least at a minimum, have to go based on where they're charged. The RICO issue, that's a different sort of a ball game. It's like, what exactly happened on the 6th that caused the conspiracy to go forward? We are not charged with any of the predicates. The predicates take place after the safe harbor date. If we go through all the actual predicate counts, right? There's 100 and something overt acts, only about 20 or 30 of those are predicate. And all the predicate acts are false swearing, forgery, those kinds of things, along with what happened in Coffee County. And I think they'd have a different position on it, because after the 6th or the 7th, you can't appoint a president anymore. All the votes could have been fraudulent. We figured it out on January 8th. It's too late to do that. And so I'm sure the Coffee County people will talk about their actions that happened after the Congress met. But my point to the court is all the substantive counts in our overt acts and predicate acts are post safe harbor date. And if nothing else, I would just say, at least in the alternative, we should succeed on the substantive counts if the court says that 2-day hook gets you on the RICO part. But I think I'll have some other arguments for that if I can save some time for rebuttal.
Sure.
Thank you.
All right. Who do we have on the state side?
It'll be me,
All right.
Judge Will Wooten. And surprisingly, I don't have a PowerPoint today.
Fair enough.
I'm going to keep this brief.
Well, can we jump in and then I'll let you have at it. But I want to focus on this idea. So the state, I think, primarily responds back, not only saying the Supremacy Clause analysis doesn't really apply here, but this is a speaking demur and we can't go that route. So even with a special demur, we look within the 4 corners of the document, right?
Yes, Judge.
So if we look solely to the document, and then we've also got a law in the books that says this is how the ECA works, can we reach the substantive issues of law and say the law as interpreted a certain way could not be a crime as alleged in this indictment?
State's position is absolutely not.
All right, why not?
Well, I don't want to give the full analysis because I don't want to waste the court's time, because I don't think this motion is really going anywhere, frankly. But as the court pointed out, preemption is either express or implied. There's been some argument, it was a little unclear what the other side's position is as to express preemption, but they've pointed to no statute, no constitutional provision that expressly says the states shall not prosecute any state crimes related to the Electoral College. That's what express preemption would be. That doesn't exist. So moving to the implied preemption, as the other side pointed out, there's a couple ways that the court can find that there is implied preemption. First is field preemption. That's where the federal statute kind of occupies the entire field. And so I kind of want to hit on an inconsistency in the other side's argument. They point to all these other Georgia state statutes that have to do with the Electoral College, you know, how electors are selected, how the governor has to tally the votes, et cetera. It's very clear from that alone that the field is not occupied fully by the federal law as a first issue. As a second issue, and again, we rely largely on what's in the brief and the cases that we've cited in the brief, but the case law says that as it relates to field preemption, what you look at first is what is the field? And so the Electoral Count Act, the field there is how does Congress receive Electoral College votes from the states? How do they determine which ones are the real ones? and how do they count them? That's the field. The field for the Georgia criminal statutes that this defendant is charged under has nothing to do with that. They say nothing about how do you count votes, how do you submit votes, how do you determine, which votes to count. The Georgia criminal statutes say nothing about that. They're entirely different fields. They're fundamentally different bodies of law. And so it's clear that there is no field preemption. The other thing that I would point out on that, Judge, is the other side has said, again, an inconsistency or an inaccuracy that Georgia law kind of foresees this idea of multiple slates of electors because 21-499B says that the governor and the secretary of state have to look at the slates of electors, figure out how many people voted for each, and then determine who the winner is. It's referring to multiple slates of electors in that statute because it's pointing out that the state government has the responsibility to look at each slate that's on the ballot and figure out who the winner is. There can only be one winner. And in this case, the state government did that, determined that it was the Biden electors that won. And then that's what a certificate of ascertainment was created that acknowledged that fact. Additionally, the other side says something about the Electoral College or the Electoral Count Act allows for multiple slates of electors. No, it does not. There's reference to multiple Electoral College votes in the Electoral Count Act from the perspective of what is Congress to do to figure out which slate to vote. But just because, which slate to count, just because the Electoral Count Act foresaw that people might submit false or, unauthorized slates of electors or Electoral College votes, that doesn't mean that the Electoral Count authorizes that and says that this is okay to do. It provides instruction to Congress as to what to do in that circumstance. And again, Electoral Count Act says nothing about states can't prosecute fraud crimes related to the Electoral Count Act after December 8th. That's frankly made up out of thin air. Another thing or moving on from field preemption, as the other side pointed out or alluded to, the court can look for conflict preemption. So is it possible for someone to comply with both laws? In this case, absolutely yes. As we pointed out in our brief, the actual electors for the state of Georgia demonstrate that. They complied with the Georgia state law that was in accordance with federal law, the Electoral Count Act, and they didn't commit any fraud in doing so. And I try to think of examples of where there might be some kind of conflict preemption. The best I can come up with, Judge, is if there was some Georgia law that said, under no circumstances shall the electors for the state of Georgia submit their votes to the president of the Senate. That clearly conflicts with the Electoral Count Act that says that's what the electors have to do. That would clearly be an example of preemption, but that's not what we have here at all. There's nothing that's in direct conflict. I don't know where this idea of December 8th and safe harbor, divesting the states of the ability to do anything if there's fraud in the electoral college voting process. I don't know where that comes from. There's been no support for that other than here's the Electoral Count Act and this is what we say that it means. But there's nothing in the briefs or in the argument that addresses that. Judge, that's all I've got. I did want to mention one other point. The other side said that the federal court, the district court of the street took up this issue. The court did take up this issue a little bit in the context of removal and completely rejected it. Said that is not applicable at all, that interpretation is not correct, that these, the quote, alternate slate of electors, they never were electors. And so none of this applies. So with that, I'll take any other questions that the court has. Thank you.
Mr. Roy.
I'll just put up the slides again because I have no idea how to respond because it seems like we're talking past each other on two different cases. They say the governor's certification determines who won and that's the winner and they counted that. The absurdity of that statement under the statute, you start the legal challenges after the governor certifies who they think may have won. They can vote for anybody that they want. That's when the process starts. It's like it makes my head hurt because we keep talking about the same thing from their pleadings. The governor's certification is essentially meaningless under federal law. That's the whole point. It's just a tiebreaker that starts the challenges in court. That's what was happening here. So when they say who won is decided by the governor. It's completely false. Congress decides who the winner is if there's multiple slates of electors. I am sorry that we haven't had ECA challenges in the 140 years that's gone on. This is a unique case. The only thing I can tell you is we looked at Hawaii, even though it can be distinguished in some phases, but multiple slates of electors, 3 slates of electors went up in Hawaii. Had the government's theory, and they said in federal court, had the Democrats done what they did, they would have indicted them. Had Fonnie Willis been the DA, Nixon would have won Hawaii. And the whole skew the country could be different theoretically as to what happened because the Democrats did an alternate slate of electors in that case. So when they say the ACA doesn't allow alternate slates of electors, and I don't know what they're reading. It talks about it 5 different times. And if you look at the history, and I'm sure you have, the whole point of the ECA was multiple slates of electors were coming up to Congress year after year after year. And that's why the ECA was crafted in the way and said, if you get multiple slates of electors, this is what you do. And in 2022, they corrected it again because there was still mass confusion. They say we don't cite any statutes because there aren't any. The Georgia statutes that apply are procedural. They don't say how you're supposed to vote. They say no electoral college case law exists because it's never come up before except Hawaii. And they did the exact same thing that the Trump people did in this case. They filed a separate set of electors. So I gave you the Georgia law. What allows you to force a separate set of electors? 1% of the vote. If it's confirmed, you can then select it. And if you go back to the second slide, please. Next one. Keep going. Keep going. Keep going. If we look at 21-11, when Georgia talks about, as the DA tries to implore to you, that we control how electors do whatever, it specifically says in the statute, as Congress has directed. That is a direct quote under Georgia because we just do procedural things. The voting issue is solely a Congress issue. And the safe harbor date is in the ECA, and it says that's when everything's due. Otherwise, we get the power back. That's why there's structural, that's why there's field, and that's why there's conflict preemption. You take your pick of a trifecta in this situation. To me, it's structural after the 8th of 2020. I'm sorry, December 8th of 2020, as far as that goes. So I apologize. I don't have any idea what the government's argument is. And if we needed case law and everything, it cuts against them because due process requires that you can't be prosecuted for a novel theory under the law. It has to be put on notice. And if the ECA is that vague, you can't just prosecute us because you feel like it. Everything we did was in compliance with the ECA following those rules. And that's not state fraud because it's not even fraud. If you can have a second slate of electors, you can de facto not have a crime. Thank you.
All right. I'll take that under advisement, written order to follow. And I think you've already provided the PowerPoint as well.
Yes, Your Honor. Do you want a hard copy or is it okay?
No, that's fine. Okay, let's move on and talk about the First Amendment.
Yes, Your Honor. I don't have a PowerPoint for this one, so I'll just have to bore you with my.
Not at all.
I think most of the issues have been taken up, and essentially the government's argument is everything's a crime, so the First Amendment doesn't apply. And if that was the case, I would agree. But if we piggyback on and adopt what I just said regarding the ECA and what it says, I think that all sort of goes out the window. I would correct the state in my reply brief on 3 of their cases that they're trying to use to say that, we're wrong. Let's look at Alvarez. It says, indeed, the U.S. Supreme Court has even said that false statements are protected and inevitable in an open and vigorous expression of views in public and private conversations. Those are statements. In this case, we're talking about the memos and things that he's written. We then, as I've cited, go into, even when considering some instances of defamation and fraud, the court has been careful to instruct that falsity alone may not suffice to bring the speech outside the First Amendment. The statement must be a knowing or reckless falsehood. And that was under Alvarez as well. I think I've cited that out there. So I think you have it in our reply brief. And lastly, under Eastman versus Thompson, which is the only real case that we have here, one of the memos that was looked at under Eastman's disbarment proceedings by the federal court in California, they specifically said that the memo that this man had written was in anticipation of litigation. I don't know if work product were used, but they gave explanations. But in that case, the court found that Eastman may have leaked that memo and therefore it doesn't get those protections. But we're not Eastman, and there's no evidence that anybody from the Trump side has ever leaked anything. But that's getting into another brief. But as far as the First Amendment issue goes, it's all protected material under sort of that case law. And the cases that the government cited was Nordahl, Nordahl. And in that case, they're citing it for a proposition, which is a cherry pick sentence out of a footnote in that case. And I know I've been good with footnotes and the court has sort of pointed that out, but I would just point out that that's not the holding in the Nordahl case, as the government tries to say. In Yates, which the government cited, they're citing as the holding something out of the dissent from Justice Black. That's not accurate. Under Alexander, as they cite too, they're talking about criminal and civil sanctions and not a RICO charge itself for the crime, but sanctions, whether those fall under the First Amendment protections. I think it all speaks for itself. The issue is going to be the court has to look at, as we put in our pleading, there are a ton of emails that are sent out to other lawyers and high-ranking individuals in the Trump campaign that we represented. And so the court has to see on an in-camera case-by-case basis, I guess, is anything subject to the crime fraud. The only guidance I have to give you is you have the Eastman case out there, and it specifically talks about at least one of the 3 memos that he wrote that is work product, or excuse me, anticipation.
Are we getting more into the third motion? I thought we were talking solely, I think you made an as-applied First Amendment challenge.
Right, as applied, what I'm
Right.
saying, it's hard to sort of keep it a little separate. The point is,
Okay.
we made these, right? What's an exception to the First Amendment, right? Crime fraud issues come up there. If it's, you can't advise somebody to commit a crime and hide behind the First Amendment. What I've cited is falsity, depending on however you define that, isn't sufficient under it. It's got to go way beyond that. Even they said, somewhat of a recklessness as far as making false statements up isn't going to go there. Otherwise, we could prosecute everybody. The issue then becomes, at one point, does the First Amendment not apply? Is it purely a crime? And so it feeds into what Mr. Grubman's going to argue is, if you don't see the legal advice for what it is as far as their speech. I mean, first we have the legal advice protections, right? Then we have the First Amendment as an alternative to say you can say these things and you can put it out there. There's nothing illegal if you actually read the memos that they've got. We've got case citations, law review articles, learned treatises. Everything's been posted in there. On every sentence, there's almost a citation. I wish the government would not have put the stuff I was challenging as attorney-client protected into the world. I know a lot of that stuff may already be out there, but if you read it, it actually deals, his statements to me are legal, but then they're also First Amendment protected. And I don't think it goes way past that reckless standard where the First Amendment wouldn't apply to these cases because we're being so reckless with the facts in the case. So I think.
Well, so this is one, again, like I'm kind of alluded to, is you've reined it in by saying this is an as-applied First Amendment challenge for this motion.
Yes, Your Honor.
And so can you point to any other as-applied First Amendment cases that happened in a pretrial context? Because everyone I've seen in Georgia, whether it was challenging terroristic threats or the anti-mask law or everything else, they had a record to go on. We don't have that here.
We don't have that here, but you actually have the exhibits as part of the other cases, right? The exhibits and everything are in the indictment. They cite to the emails that we're talking about. They cite to one of the 3 memos, I think, that they're talking about as overt acts, and then possibly leading to the under predicate advice that we gave advice on how to do the vote, and how to do all these other things. So I think there's a slight difference in that you don't need to listen to all the evidence, go back to a directed verdict stage. At this point, if you just look at the indictment and the things that they're saying, we're saying, obviously one of the factors was attorney-client, but the otherwise it's First Amendment protected. If you look at the things that they reference and cite to in their own indictment, are those so reckless false statements that it goes beyond the First Amendment protections? So I'm not asking the court to go beyond the 4 corners of the indictment, but they actually cite, instances in there. And I'm saying,
but so much of what is reckless,
yes,
is a question of intent, right?
I would agree.
So I just struggle how we're supposed to. This again seems like something for a directed verdict,
Sure.
an argument, but we haven't had a deposition in the record. We haven't. I mean, I think now you've introduced an affidavit, but that kind of challenge, the give and take, that hasn't happened.
Well, I mean, all I can sort of go back to is, I know this necessarily doesn't apply. Like if we do justification, for example, we talk about we can deal with it up front because the stress of the trial and all that. You have a lot of these facts before you. You can expand, we can contradict, we can do whatever. I'm just saying, look at the indictment. It says, he says this in this memo, or he says this in this email. Take aside the whole attorney-client issue. Is saying those things or emailing those things a violation or an exception to the First Amendment protections that are listed out here, what things, go around the First Amendment? And the state's response is mostly, the criminal type aspect of it all. I don't see how the court can't make that challenge. Otherwise, we could literally try anything as far as that goes. This isn't a terroristic threat, as in when he says, I'm going to kill me, did he really mean that? Is it this? This is purely legal advice that's given in the indictment. And the question then becomes, is it so reckless and criminal based on the four corners of the indictment that you can't make a decision on it, versus forcing us to go through millions of dollars of expenses in a trial and then get the result we need at the directed verdict stage, which obviously the court knows will be a pretty big directed verdict motion coming if we get to that point. And so I don't have anything clear to give you because we're in a case of essentially first impression as far as the politics and attorney legal advice goes. And we're sort of all kind of making it up as we go along, trying to interpret the best that we can from the legal treatises and articles. And I try to cite you the best that I can. And at the same point, the government's citing you things. And we've gone back to when we first started with the speed trial. We don't have to give you discovery. And then that was all wrong, right? So I'm giving you the cases that they're citing for things. That's why I ask, please, I know it's a lot, but if the court reads it, you'll understand. I'm trying to be as open as I can, giving you all the but-sees and footnotes and everything good or bad. But I don't see how we get the trial based on the old motion. But here, I mean, because at that point, what attorney is going to give advice to anybody if it can be looked at something by a DA that says otherwise? So you go back to Hawaii, and if you look at the transcript from the federal court, they specifically said, had that happened in Hawaii, we would have indicted those people. And then Nixon would be president, arguably. So just because you don't like the person doesn't mean you get to prosecute him.
So, and Mr. Roy, I can certainly appreciate, the situation we're in and the candor that so many of these things are uncharted. But what I keep coming back to in a lot of these pretrial motions is the appropriate role, what the jury is supposed to be doing, what I'm supposed to be doing. And so much of this is, it seems like both sides are eager to dive right into it and start doing battle. But all too often that doesn't seem like what the role is via pretrial motion. And is it inefficient? Absolutely. Should there be maybe a defensive summary judgment standard? Perhaps, but I've not seen that.
I'm not disagreeing with you at all. I'm just simply saying, if we sort of shut the blinders on and look just at the indictment kind of thing, you look at the language, that's all I'm getting at. I'm saying I totally agree and understand where you are. But we are about to have a trial where the jury is going to end up being constitutional law professors by the time we're done, because all the facts are the law. And so I'm maybe trying to short circuit it because you're smart enough to know what's going on. We've had the 10th Amendment issues, we have the federalism issues. I can't give you anything else. I wish I was a great case that said, oh no, in 1892 this happened, but it just hasn't come up. And the one example that we have, I've sort of talked about, and I've told you my deficiencies, and I've cited all the law review articles I can find.
All right, Mr. Rafferty, did you want to add anything to this one?
I think Mr. Rohr has.
All right, thank you, sir. And Mr. Wooten, was this one yours?
Yes, Judge.
Okay.
I do have a PowerPoint on this one. I just want to make sure that we preserve the record on our side. Judge is telling me that there's no screen sharing hasn't been enabled.
I think we need to add you as a co-host in order to do that. Just stand by just for a moment.
Gunnar, in the future, if we're going to do it here, could we get one more screen? Because I know you can't quite see that. So I was just trying to.
We'll just rotate this. In fact, we can do it now if you'd like to.
I got the
Okay, we'll just hold off for now. All right, give it a shot now, Mr. Wooten.
All right, Judge. So I want to start out with some, again, as the court pointed out in the reply, the defendant kind of tailored the argument down to an as-applied challenge and made a couple concessions. First, the defendant concedes that speech that constitutes fraud, harmful lies that threaten to deceive the government, or speech that's integral to criminal conduct is not protected by the First Amendment. That's in their reply at page 2. And additionally, they concede that the statutes that the defendant is charged under are not facially unconstitutional. It's an as-applied challenge to these statutes. That's in the reply at page 4. As-applied challenge addresses whether a statute is unconstitutional on the facts of a particular case or to a particular party, but essentially the analysis is the same. Is the way that the state is prosecuting this defendant violating the First Amendment? And I think it's important to point out that the defendant is not charged in this indictment with any offenses that prescribe speech or expression. As the court pointed out, a lot of the cases, most if not all of the cases, and there are just a handful that present an as-applied First Amendment challenge to a criminal prosecution, are cases involving expression, terroristic threats, intimidation of a court officer, et cetera. But here, every single count is a conspiracy violation. So count 1, violation of the Georgia RICO Act under the C prong, which is conspiracy and endeavor. Count 9, conspiracy to commit impersonating a public officer. Count 11, conspiracy to commit forgery in the first degree. Count 13, conspiracy to commit false statements and writings. Count 15, conspiracy to commit filing false documents. 17, conspiracy to commit forgery in the first degree. And 19, conspiracy to commit false statements and writings. And I point that out, again, because all of those charges are conspiracy violations. For count 1 under 1614(4)(c), it shall be unlawful for any person to conspire or endeavor to violate subsection A or subsection B. And then the remaining charges are under 1648, just a general Georgia conspiracy statute. Persons guilty of that when they conspire with another person to commit any crime. And so again, I point that out because the heart of a conspiracy charge is not expression, but it's an agreement. And so in Darville versus the state 2011 Supreme Court case 289, Georgia 698, a conspiracy may be shown by proof of an agreement between 2 or more persons to commit a crime. The essence of a conspiracy is an agreement. Drain versus the state 265, Georgia 255, a 1995 case. And again, this concept is very old. We go back to Lumpkin versus the state 176, Georgia 446, a 1933 case that says, and this is still good law, it's been cited over and over again, but a conspiracy consists of a corrupt agreement between 2 or more persons to do an unlawful act. And this is crucial. This agreement may be established by direct proof or by inference as a deduction from conduct. And I'm going to get into that in just a minute. But again, the crimes are all about entering into an unlawful agreement to violate the criminal laws of the state of Georgia. The speech or the other expressive conduct of the co-conspirators that they are charged with in substantive violations is not the meat of what this defendant is charged with. And as our Supreme Court, United States Supreme Court held as recently as this year in United States versus Hansen, 143 Supreme Court 1932, not expressive conduct does not implicate the First Amendment at all. I'm going to turn to the statutes. And as the court pointed out, a lot of these arguments go to things like intent. A jury can find that a defendant or this defendant intended to enter into these unlawful agreements or conspiracies upon consideration of the words, conduct, demeanor, motive, and all other circumstances connected with the act for which the accused is prosecuted. That's 16(2)(6). And I point that out to demonstrate to the court that our law contemplates that in proving a crime, you can use the defendant's words or expression or conduct or demeanor against them. And in no way does that violate the First Amendment if it's used to prove the violation. And so the state will prove the defendant's participation in these conspiracies primarily through his conduct. Some of that, but not all of that conduct is speech. The defendant contends that the sole basis for alleging and proving that he was part of any of the conspiracies charged is his legal analysis and advice. That is not so. And as the court pointed out, almost all of the cases, I could find one where there was a pretrial appeal on this, but almost all of the cases were post-conviction. There was a full record. It gave the court something to make a decision on. In the one case that was an interlocutory appeal, the facts were stipulated to. It was a Facebook post where someone threatened to like shoot up their school or something like that. So the facts weren't an issue. Again, for the purpose of building a record, I'd like to just go through the indictment and point out how the conduct that forms the basis of these charges, or the acts that form the basis of these charges, is conduct. Some of it is speech, some of it is not. So we start with count 1, Act 47, and I'll move through this quickly, but on or about the 10th day of December 2020, the defendant sent an email to Georgia Republican Party Chairman David Schaefer and an unindicted co-conspirator. In the email, he stated that certain individuals associated with the Trump campaign asked him to help coordinate with the other 5 contested states and help with logistics of the electors in other states, hopefully joining and casting their votes. So the way that it's alleged in the indictment, part of that is speech, but part of that is the defendant admitting that he's doing more than just providing legal advice. He's involved in setting up of logistics for these meetings that occurred in multiple states on December 14th of 2020. And we've included in the PowerPoint the email that refers to. And again, he says, like I said, he was asked by the Trump campaign to help with the logistics of making sure that people meet and cast these votes. That is not speech. That is not expression. That is not legal advice. Count 1, Act 48. The defendant sends another email to David Schaefer where he provides documents that are to be used at the meeting on December 14th of 2020. This is that email. Again, he says he's following up and providing these draft documents that he created. This is not speech. This is not legal advice. This is not expression. He's providing instructions on how to fill out those documents, how to mail them. He even gets as granular as saying that you need to send them by registered mail. These are the attachments, the documents that were on that email. And then, of course, they end up being the documents that were submitted by the co-conspirators. So the defendant created these documents and distributed them, not speech, not expression. And I'll move through quickly. Count 1, Act 49, similar thing in Arizona, distributing documents. Count 1, Act 50, similar thing in Wisconsin. Again, providing those instructions, distributing those documents. Count 1, Act 51, similar thing in Nevada. Count 1, Act 52, we go back to Nevada again. So, and again, and I want to point out, defendant contends that all he did was provide legal advice. None of these people that these emails go to are his clients. So I don't know how that could be construed as legal advice if they're not his clients. Act 53, again, same thing as it relates to Pennsylvania. Essentially the same emails are distributed out to all these people. Act 58, again, talking about the purpose of sending these things in is to provide the opportunity to debate election irregularities in Congress and keep alive the possibility that the votes could be flipped to Trump and Biden. Not speech, not expression, not legal advice. Act 59, more emails, documents sent to Arizona. Again, those same instructions. This is how you address them. Make sure you send them by registered mail. These are all instructions on how to submit these fraudulent documents. Count 1, Act 60. Again, providing more documents to more people, this time back to the Trump campaign. Count 1, Act 61, more instructions and documents that this defendant created being sent back to the Trump campaign. Count 1, Act 64. This one was a meeting. So this was actually meeting together with co-conspirators. Again, not expressive, not speech, not legal advice. Count 1, Act 69, another email distributing documents for New Mexico. Count 1, Act 72, another email. This again is providing instructions saying that the mayor, Rudy Giuliani, wants to keep all this quiet until the voting is done. Again, not legal advice. This is talking about a political process, the meeting of these fake electors, how they don't want anyone to know about it. A couple of, and I'm going to wrap up quickly here, Judge, but a couple additional considerations. The state is not required to prove that the defendant committed any overt acts. I think that's significant because while we do reference certain overt acts in the indictment, and some of those are speech, that's not a fatal issue with the indictment because we don't have to allege any overt acts whatsoever. As we've discussed in prior hearings, Each actor in a conspiracy is responsible for the overt actions undertaken by all the other co-conspirators in furtherance of the conspiracy. Pasha versus the state, 273, Georgia App 788, 2005 decision. That was a RICO case. I also kind of want to point back to something that the court pointed out on the other motion. But again, count one, I believe the first date, talking about this safe harbor thing, the first date is November the 4th. And again, you take out all these defendants' overt acts, he's still liable for all of the other co-conspirators' overt acts. So it doesn't matter if you strip out these post-December 8th acts. Additionally, overt acts in furtherance of a conspiracy do not have to be crimes. It's not necessary that an overt act taken by itself even be criminal in character. That's from Yates, 354 U.S. 298, 1957. And essentially, Judge, the defendant's motion should be denied. He's not charged with any crimes that prescribe expressive conduct. He is charged with all conspiracy crimes. Non-expressive conduct does not implicate the First Amendment, and the state will prove his participation in those conspiracies through his conduct. Some of that is speech, and that's entirely permissible. It happens in just about every strong criminal case. You use the defendant's words and actions against them, and that's never raised any constitutional issue. And I'll take any questions that the court has.
Thank you, Mr. Wooten.
Judge, I hate to say this, but I feel like, again, we're sort of talking past each other. They're talking about conspiracy and that you're responsible for everybody. But actually, if you read the case law, what the law on conspiracy says is you don't need to have full knowledge of what your co-defendant's doing, but there's a certain amount of knowledge that is required. That's for tomorrow. I'm not really sure why it's normal here. So we start off with, there's no speech or expression or anything else. And then we go with, well, we're going to use his own words and conduct and expressions and emails against him. All these acts that are listed deal solely with the emails out there. And you are an IG, you tell your clients, these are the rules and this is how you're supposed to do it. So when he's saying you got to fill it out this way, do it in triplicate this way, mail it this way. That's what the ECA issue was that we just talked about. That is what a lawyer is supposed to do when giving advice to his clients on how to fill out their tax forms or how to fill out your license application. I mean, that's the core crux of what a lawyer does. So again, I don't know how to respond to this. The First Amendment issue is you can't just say it's a crime and we'll prove First Amendment later, because then you have no First Amendment protection because you go to trial every time. Just because you say it's a crime, does that mean your First Amendment goes away and we got to figure it out at a directed verdict motion? It's not an affirmative defense necessarily where you can sort of litigate it and the jury decides. You get to decide up front based on the four corners. Their own acts that are listed talk about, he sent an email explaining how to fill out the applications for the voter stuff. He sent an email saying how you mail it in. He sent an email saying, this is how we're going to do the logistics of something. That's inherent First Amendment speech. Otherwise, we literally would have no protection if everybody could go to trial just because the DA gets a wild hair and says, I find that to be criminal. So I don't want to take up any more time. We're just going in circles. I mean, the First Amendment is the First Amendment is the First Amendment as to what he said. Just read what they've listed in there. How is there an exception to the First Amendment in the four corners of the indictment? Thank you.
All right. All right. And then the last thing we had was the motion to exclude legal memoranda and correspondence. I know we kind of started talking about it, but now we can address it full on. I think specifically it's been 5 documents have been highlighted. Mr. Grubman, were you taking this one up?
I was just going to say, I've been talking. Can we take a 2-minute bathroom break and then get right into it?
Sure, that's fine. We can break for 2 minutes.
Can you put that in? Use that for mine.
Yeah, if you find an outlet.
you doing? Yeah, there it is. Wait, no, those are just, okay. Oh, there you go. I decided to wear my felt pen. Also felt pens. I remember being at the DOJ, it's like, they didn't pay us much, but they gave us lapel pins and challenge pens. It's like, yeah.
Amazon, $2.
I'd rather have more salary, but okay. Yeah, you'll know.
Stay seated, please. Thank you.
Your Honor, I'm just going to give you the sheet with the case citations that I talked about in the first one. That's okay. Email to the governor. A couple I didn't mention if I didn't.
Oh, just don't listen to state. Are we ready to get back to it? Okay, Mr. Grebman.
Good afternoon, Your Honor. Here to talk about our motion to exclude any legal memorandum and affiliated correspondence for attorney-client privilege and work product. I did want to clarify something that the state said in their response brief and that Your Honor just mentioned before we took our restroom break, which is this is not just about 5 documents. As we make clear in our motion, it's about all documents, whether emails, texts, or memos that are privileged. We used 5 examples in our motion because those were the ones that were cited in the indictment. But we clarified in our motion, we're asking for the same relief for all documents protected by privilege or work product. And quite honestly, Your Honor, the vast majority, I know there's quite a bit of overlap, and I'm going to try to avoid the overlap with Mr. Aurora's First Amendment arguments, but there is some inevitable overlap. And the vast majority of evidence against Mr. Chesborough, we would argue, consists of emails, texts, and memos. And the majority of those emails, texts, and memos were to 2 categories of people. The first one is folks associated with the Trump campaign, which was Mr. Chesborough's client. I know that is something that the state challenges, and I'll address that in a moment. But Mr. Chesborough's client was the Trump campaign. I think that is clear. And the folks he was talking to, for the most part, were not only members of the Trump campaign, but very upper echelon members of the Trump campaign that were put forth as members of the Trump campaign to be his points of contact. And when you are representing an organization, you do talk to people, and you don't necessarily represent those people, But if you're talking to those people in their role as either an employee or an agent of your client, then those communications are privileged. And then the other example of who he's talking to are other lawyers. So all the folks that are basically listed, I'll just name some names. You have Rudy Giuliani, you have Josh Finlay, you have several other people. They're all attorneys for the Trump campaign. Now, first question is, was Mr. Chesborough even acting as an attorney for the Trump campaign? And quite honestly, Your Honor, I'm not trying to engage in, I was very surprised, we'll just say, when I heard that the state does not think that is even a fact that the court could rely on. I'd like to pull up a reply brief that the state filed back when they were trying to get Mr. Chesborough to come before the special purpose grand jury, because it makes clear that they agree. If that can happen, and it's okay if it can't, but they make clear that Mr. Chesborough was acting in his role as attorney, and even acknowledge in that response brief, you'll see that while the majority or a lot of what he talks about might be protected by privilege, they just don't think all of it is. If you can go up to one, I think. I'll just have to look at it a second. Further, the district attorney agrees that certain information known to the witness may be protected by both the attorney-client privilege and the duty of confidentiality. Still, it must be noted, blah, blah, blah. Essentially, they say not all of the information implicates privilege, and therefore we can still ask him certain questions. But the clear implication here, Your Honor, is that even the district attorney acknowledged in this publicly filed pleading, he was acting as an attorney. So as a threshold question, the first memo they cite in their indictment is a November 18th memo from Mr. Chesborough to another lawyer. And the only reason I feel comfortable speaking about this, I don't want to be accused of waiving it, is because it's already out there. And the state was nice enough to include it on their response brief. But the first memo he writes says on the top, privilege and confidential. I don't know what the other alternative is. I mean,
You're
I guess
about the November 18th.
Yes, sir.
Okay.
Sorry.
So, and maybe just by way of proffer, since I don't have
Yes, sir.
the benefit of the discovery or the background like you do, I know in the First Amendment motion, you said that he's approached by a former colleague, a judge, asked to provide some research. Essentially, what is it? What is the moment when you're saying he crosses the threshold and becomes?
Oh, the moment that phone call happened. That's what lawyers do. I'm called all the time. Hey, Scott, can you provide some research? And it's not because they're calling me as their accountant or their friend. They're calling me as their lawyer. Lawyers provide research. Lawyers write memos. So the moment James Trupis, who goes by Judge Trupis up in Wisconsin, picked up the phone and said, Ken, you're an election law scholar. You worked on this in Bush v. Gore for the Gore campaign. Can you please help with some research? From that moment on, he was an attorney. Now,
Is that because the judge is part of the campaign?
Yeah. Well, no, the judge was an attorney for the campaign. And the judge clearly was an attorney for the campaign. In fact, I'll tell you, there are pleadings in November of 2020, December of 2020, in the Wisconsin courts, which is where Mr. Chesborough was really doing a lot of the work at first, where his name's on the brief as an attorney for the Trump campaign. And I will tell you, there is no engagement letter. But the law is absolutely clear. There doesn't have to be. He was an attorney from that moment on. So I hope to just be able to move past that part. I think there's clearly, generally speaking, I know there's still an argument as to whether everything he did and said was in his role as attorney, but hopefully it can be accepted by everyone now that he was an attorney. Now, they put up a lot of emails that talk about things like logistics. And they say, well, how could a lawyer talk about logistics? Your Honor, I'm not trying to be flippant, but 98% of what I do as a lawyer, unfortunately, is talking about logistics. And if you pull up, and you don't even have to do it, Robert, because if you pull up the documents where he's talking about logistics, the state skips the part about what the logistics of what? The logistics of the Electoral Count Act. So clearly logistics is part of a legal, a lawyer's legal job. All of these, pull up the December 13th email from Mr. Chesborough to Mr. Giuliani. And this is a cited in the brief or in the indictment, and it's apparently a controversial email, but I want to pull it up. December 13th. Yep. I really wish we just had one of those old school, go down a little bit. All right, stop right there. This is the beginning of Mr. Chesborough's email memo to Rudy Giuliani on December 13th. And for those of you, I know Judge is familiar with, but for anyone who's not familiar with these citations in the paragraph that says, I have not delved into the historical record, right? These citations at the end are what? They're law review articles. This is a legal memo. And it might be controversial advice. And you know what? I'm not admitting this, but it might even be incorrect legal advice. God knows I've given some in my career, unfortunately. This is a legal memo. All of the other emails that he's reaching out about logistics, again, in all of the states. So they use Schaefer as an example, and they also reference, and I agree with them, that email that Mr. Chesborough sent to Mr. Schaefer in Georgia is essentially duplicated in 5 other states around the country. But it was the same exact email. In fact, I think it was literally copied and pasted with just the name of the state that was different. But it's about the logistics of here's what you have to fill out. In fact, I was glad that my colleague on the state side, Mr. Wooten, pointed out because it's actually something I'm going to talk a lot about in trial. I'll give them a heads up for it, talked about how granular the advice was. Mr. Chesborough saying, you have to send this stuff via first-class mail, not FedEx, not registered mail. Why? Not because Mr. Chesborough says so, because the Electoral Count Act says so. This is an extremely complicated statute. And the fact of the matter is that everything he sent was legal advice. Now, of course, we'll talk in a few minutes, Your Honor, about I think what the real crux of this argument is going to be, which is whether there's an exception to privilege. But to start with the premise, these things have the kind of prima facie case of privilege. Let's talk, before I get into crime fraud, which again, I think is going to be the most important, just talk about waiver for a moment. And there were a couple of arguments. First of all, this is such a weird case in that we're trying to keep out evidence
we're looking at
and that, every housewife in Kansas has seen on, Fox News or whatever. But the fact of the matter is, unless there is evidence that the privilege holder, and I want to be very clear who the privilege holder is here, Trump campaign, not Mr. Chesborough, not anyone in this room. The Trump campaign is the privilege holder, and Mr. Wooten even acknowledged that in his response brief. So the privilege holder has to have been found to waive privilege, and they can do so expressly or through actions, of course, inconsistent with privilege. So, for example, if there was a shred of evidence, which there's not, that the Trump campaign itself leaked these things to the press or whoever it was, we would be arguing something different. That would be an issue. In fact, that kind of came up in the Eastman case. Eastman case is so interesting because the judge there found this does not fall under crime fraud exception, but found that it was waived. But in there was evidence that the court kind of referenced to talk about, there was evidence to suggest Mr. Eastman himself waived this stuff. And there, of course, the argument is, well, you can't use it, as a sword and then also as a shield. But there is no evidence, and I can absolutely guarantee you as an officer of the court, that Mr. Chesborough ever leaked this. In fact, the evidence will show, if the judge needs if the court needs an evidentiary hearing, I don't know, but the evidence will show that every step of the way, and I hope the state will agree with this because they were there and it's in writing, Mr. Chesborough maintained privilege. He got subpoenaed to be called before the special purpose grand jury. And as on the advice of legal counsel, he objected on the basis of privilege. He asserted privilege when he was interviewed for the January 6th committee, which I can say because it's all on Google. You can Google it. For over and over and over, he asserted privilege. And he's always asserted privilege. And even more important, we have one communication from the Trump campaign back in September of 2022, when Mr. Chesborough was figuring out what can he say and what can't he say, because his hands were tied. He's a lawyer, can't say anything he wants. And that email from the Trump campaign, which I would prefer to show the court in camera if appropriate and needed, specifically says it's for a lawyer for the Trump campaign and says, at this time, no privilege has been waived, and we instruct Mr. Chesborough to maintain all privileges. And I am not aware of any time that the Trump campaign has done otherwise. In fact, I just saw on Twitter today, and this is going to be relevant, I promise, because I think it proves the point, that a judge up in Washington, D.C., in President Trump's D.C. case, said you have to make a decision, President Trump, by December or October 18th, whether you're going to assert advice of counsel and therefore waive privilege. Well, that means to me clearly that the Trump campaign has never waived privilege. Now, the fact that folks may have turned over, attorneys or other people may have turned over these documents to the January 6th committee in response to a subpoena, I would have to do a little more case law research, and I apologize because the response brief came in late last night, but I can if the court finds it important. I don't think that can be found as waiver. But moving aside from waiver, I think, and of course I'll answer any question you have, Judge, and there are some cases that I did not print them out. I will send them to the court, just read them really quickly. And Judge, I'm going to go ahead and tell you right now, I apologize. These are not Georgia cases. They're not 11th Circuit cases, but I could also promise you there were none that I found either way. There's a case from the Ohio Court of Appeals in 1993 that said attorney-client privilege is not waived when a memo from the city attorney to the city manager discussing litigation was leaked to the news media, where there was no evidence that the city had voluntarily relinquished the memo. And that's Ohio v. Today's Bookstore, 86 Ohio App 3rd, 810, 1993. There's also a case from the same year in Arizona, Resolution Trust Corporation v. Dean, 813 F Sup 1426, District of Arizona, 1993, which held that an unauthorized leak of an otherwise privileged legal memo did not result in a waiver of privilege. So A, we believe the prima facie showing of privilege has been made. B, we believe we have shown that there has been no waiver that would affect these documents. So now to get into the real crux of the matter, does the crime fraud exception apply?
Yeah, let me pause you there. And it seems like the waiver analysis has to be document by document. I mean, there's no other way to do it, right? So your initial motion and the reply focus on 5. And I understand you're asserting a blanket privilege, but I think you just have to take it as it comes, right?
Yeah.
So focusing on the 5 that we've started to look at here, as I recall, we'd have to look at each of them individually of how they got out there. Some we know, some we don't. One of them, I think we had one of the co-defendants, Mr. Schaefer, voluntarily giving it to the state. Why would that not be a waiver?
Because Mr. Schaefer was not, there's no evidence that Mr. Schaefer was authorized to waive on behalf of the Trump campaign. Like, I don't mean to use a derogatory example, but let's say the guy who cleans the offices at the Trump campaign came into one of the lawyer's offices one day and saw the memo. He works for the Trump campaign. That's where his paycheck comes from, and hands it to CNN back there. Is that a waiver? No, because that person was not expressly or impliedly authorized. Now, I hope you don't ask me to cite a case for this proposition. I promise I can, but not right now.
When we look at an organization, though, I don't know how the campaign was structured or organized. How would a waiver even look in this situation?
I don't really know. Here's what I will say, though, Your Honor. And again, they're not, they could only be persuasive authority to the extent the court wants to look at them. But those 2 cases I cite you stood for the proposition that unless there was affirmative evidence that the waiver came from the proper person, i.e. the client, and was not unintentional and was not, improper, unless there was affirmative evidence of a waiver, there was no waiver. And that's what the court said. quote, where there was no evidence that the city had voluntarily relinquished the memo. They didn't say the opposite, which is, well, there's no evidence either way. So even though I cannot tell you that the Ohio v. Today's Bookstore case says, quote unquote, the other side has the burden to show waiver, it doesn't use those exact words. I think that's the strong implication from these cases, because it says unless there's evidence to the contrary, there is no waiver. And there's evidence quite to the contrary, Judge, that, for example, if Mr. Schaefer, and nothing I say, I want everyone to understand, I'm sure his lawyers are listening on YouTube, nothing I say is accusing Mr. Schaefer of any wrongdoing whatsoever. But let's just assume for the sake of argument that Mr. Schaefer released these documents. I'm not exactly familiar with all of the facts related to him. But the Trump campaign since then has taken steps to make clear that they're maintaining the privilege. For example, that's the reason why on October 18th, they have to decide up in DC. And those are, remember, Your Honor, much of the case in December 18th that President Trump is being prosecuted for is very similar to what Mr. Chesborough is being prosecuted for. One of the issues there is the alternate slave electors. So I don't believe there's any evidence in the record either way. And I think without any evidence, the tie, even if there is a tie, I don't think there is, but even if there is, the tie goes to us. In terms of the crime fraud exception, it is absolutely correct that the state does not have to prove the existence of a crime or fraud for this exception to apply. No question about that. But just as important, if not more importantly, it's also true that simply charging or alleging crime or fraud is not enough. And there's a case on this. It's a little newer than Mr. Aurora's case. My case comes from 1935. But it has never been overruled and is from the Georgia Court of Appeals. So I finally found the Georgia case. It's called Atlanta Coca-Cola Bottling Company v. Goss, Goss. And the citation is 50 Georgia App 637. It's from 1935. And again, it stands for the proposition. It's one of those 100-year-old cases, Your Honor, where you read it and it's kind of judges spoke differently then, obviously, and kind of put stuff out there differently. But what they absolutely make clear is that simply charging or alleging a crime or a fraud is not enough. And to be quite honest with you, Judge, that case that's never been overruled expressly forecloses the first argument in the state's response. Right after they said, well, there's no evidence Ken was even a lawyer, and then there's no evidence of this. Then they say, oh, and by the way, just the fact that a grand jury indicted this man is enough. It is not. That is black letter law. And, you know, some people laugh. This is from 1935. I would seriously say, well, that means this is a nearly 100-year precedent that the state tries to get rid of in a citation to a First Circuit case. Can't happen.
You're saying you interpret Coca-Cola bottling to say that a grand jury indictment is not.
It specifically says charging or alleging a crime or fraud is not enough, which means they don't use the word grand jury. I want to be clear, but the way a prosecutor charges or alleges a crime in this state is through a grand jury. So, you know, ipso facto or whatever that word is from Latin. I'm sure Mr. Chesborough would know.
That's gonna be a civil case, right? So, you know,
yes,
when they're using the word charging, that could very easily just be a
statement,
a term of
sure,
synonym for what you might be doing right now, right?
Well, and look, Your Honor, I hope that in the State v. Chesborough update to the case that comes out in 2023, Judge McAfee clarifies that it applies equally in the criminal setting, but that is a fair point. Second, they go on to say, okay, in addition to the grand jury indictment, Judge McBurney issued an order, an out-of-state. Okay, I don't have to even talk about that. Ironically, Your Honor, I will just say this. In that order, in the Judge McBurney order, the out-of-state order, he specifically says, and the state says this in their brief on the bottom of page 13, I believe, Mr. Chesborough was an attorney for the Trump campaign. So kind of can't have it both ways. Then they also say, oh, well, third thing, January 6th report. January 6th report says that Mr. Chesborough and his cohorts committed a crime and a fraud, and therefore that's enough of a prima facie showing. And I should have said, Your Honor, and I know you know this, but just for the record, that's the question. The state has to make a prima facie showing that a crime fraud exception applies. So January 6th report, it does say that. I'm not going to lie and say it doesn't. It absolutely says that. However, it was not an adjudicative body. It was not asked a question of criminal law. It did not follow the rules of evidence. There was no right for Mr. Chesborough to come and cross-examine any witnesses. So I would argue the fact that a bunch of politicians in Washington, D.C. wrote this in a non-peer reviewed setting cannot be prima facie case. And the fact of the matter is, Your Honor, the state has to make the prima facie case. It's almost like they're like, oh, we don't have to make a prima facie case, Your Honor, because the January 6th committee did. No, the state has to make a prima facie case. And
would there be any difference between the state coming in here in a murder case and saying, here's what the detective found, and I am now conveying to you what the detective found?
Well,
it can be a vehicle for other people's
sure.
evidence.
I do, Your Honor, respectfully think that's a great question. I do think that is a difference. I think because then there's live testimony, right? And one thing I'm going to ask before I sit down, Your Honor, is unless, of course, you find it in your wisdom to grant us the motion without an evidentiary hearing, that maybe we do need an evidentiary hearing for this. And I hate to recommend that, but that's one thing, Your Honor. I'm not trying to waive any future arguments, but if there was live testimony that Your Honor viewed and in your role as a trial court judge decided that is prima facie, then I will admit it might be hard for us to overcome because it's within your discretion.
So we're squarely within the evidentiary code. I mean, this could just as easily be a motion in limine going into trial, right? So Rule 104B, I believe, allows us, or says the trial court is supposed to consider these kind of things without needing to use the rules of evidence by preponderance standard. And oftentimes it can be conditional. It can be based on proffers. So what would stop the state from standing up and saying, this is what we proffer? Our entire case is going to be showing the crime fraud exception applies here. And assuming this is what we connect up, that should come in. Now, if they don't meet that proffer, well, now we're in mistrial land and whatever remedies or curative instructions or the whole trial is a wash because they failed to do what they said they were going to do. Why is that not procedurally how this should work?
Because I believe, Your Honor, that the case law makes it clear that it has to be a prima facie case has to be proven through evidence and not allegations. And in fact, two cases I'll cite for that are the same one I cited earlier, the Goss case that I won't recite, but then also the Rose case, which we do cite in our motion, and it is a Georgia Court of Appeals, Rose 262, Georgia App 528, which is 2003. That was about the accountant privilege, but the court specifically said that the same rules apply. So they used the rules regarding attorney-client privilege. And that case stands for the proposition that in order to make a prima facie showing for crime fraud, you have to do so through evidence. Now, in fairness, it didn't say all of what the evidence could be. In Rose, there was a deposition where the accountant admitted that he committed fraud. Well, I can see how that could probably be pretty good prima facie evidence to support a crime or fraud. Mr. Chesborough has never admitted anything, let alone that he committed a crime or a fraud. So respectfully, Your Honor, I think the state must rely on evidence, and not only evidence, but evidence independent of the attorney-client communications. Now,
sure. But when you say evidence, in what form are you contending that evidence has to be in? Because otherwise you're saying they have to prove their entire case first and then they've established it?
Not necessarily, because there would be different standards. It's not true that the crime fraud exception would have to be proven beyond a reasonable doubt in order to apply. Side
question on that note, since you bring it up, in researching and seeing all these cases here and out of state, have you ever seen anyone try to quantify what that prima facie case is?
I looked, and it was so circular because it basically said prima facie evidence is prima facie evidence. It's like, okay, very helpful, Court of Appeals. But there are a couple of cases outside of our state and circuit, and I always want to clarify when I'm citing that. So these cases I'm about to cite are outside. There's In re grand jury proceedings 867 F2D 539, which is a 1989 Ninth Circuit case. And then there's a case, United States v. Marshank, Marshank, 777 F sup 1507, which is a Northern District of California case in 1991. And in those cases, the court said the state must rely on evidence independent of the AC communication. So for example, we argue the state cannot stand up and say, here's an email from Mr. Chesborough to Mr. Giuliani. It's privileged, but the privilege, there's an exception because of crime fraud. Because then that's circular. That could go around forever. You can't use the very documents that are the privilege to prove that an exception to the privilege applies, at least in the Ninth Circuit. There is absolutely no case law in Georgia.
And I wonder if that would also support your argument that we're not supposed to consider the indictment itself, since
Correct.
you can present suppressible or evidence to a grand jury, but we don't have any idea, and nor should we, of what evidence they were presented in order to consider this indictment, right?
Correct. Now, the crime fraud exception can't apply here, Judge. All of the accusations against Mr. Chesborough, and I'm not going to go into the wonderful stuff that Mr. Aurora, I'm kind of going to adopt everything he said as it relates to his first motion, but I do have to at least say a couple of things that just how some of those same legal principles apply here. Mr. Chesborough gave legal advice on two interrelated topics: the Electoral Count Act, as we already talked about, and two, and it's very hard to even separate these two, but I'm trying to just have a full picture, the vice president's role in counting the electoral ballots under the Electoral Count Act and the 12th Amendment. Mr. Chesborough's advice, even if subject to reasonable agreement, as we argue, was based on his good faith reading of the law. First, as for contingent electors, as Mr. Aurora stated, and I'll just say this and move on, at the time we were talking about, and those words at the time are very important, and I'll explain why I think why in a moment. At the time we were talking about, the Electoral Count Act expressly provided for contingent elector ballots. I know Mr. Wooten disagrees with this, but I'm going to read it anyway. 3 U.S.C. 15, quote, if more than one return or paper purporting to be a return from a state shall be received by the president of the Senate, those votes and those only shall be counted, end quote. ECA 15 then went on to provide the specific process that should be used if competing slates are received. Then in terms of vice presidential powers, which was the subject of the December 13th memo to Mr. Giuliani, the 12th Amendment says, quote, the vice president shall open all the certificates and the votes shall then be counted, end quote. Mr. Chesborough's advice, as reported in the media, was that to the extent the ECA limits the authority of the vice president under the 12th Amendment, it has to be unconstitutional. Although that proposition is not universally accepted, it's a position held by quite a number of election law scholars, including some that were relied upon by Mr. Chesborough in his memos. And here's the kicker, Your Honor, and I can't emphasize this fact enough. In 2022, the ECA was amended. I think the only thing since 2020 that both political parties in Washington, D.C. have been able to get together and do is amend the Electoral Count Act. And here's how it was amended. And I think this is so important. Official Senate summary. This is literally a copy and paste from the United States Senate's website when they're talking about the bill that became the Electoral Count Act reform of 2022. Quote, the bill revises the framework for a joint session of Congress to count electoral votes and make a formal declaration of which candidates have been elected president and vice president. Among other changes, the bill specifies that the role of the vice president during the joint session shall be ministerial in nature, end quote. Changes. If the law was changed, then clearly the law prior to the change was either that the vice president can do the things that Mr. Chesborough said he can do, or at the very least, it was unclear. And why is this important to kind of wrap it all up before I just say one word about work product? It's important because we're talking about what? The crime fraud exception. And unless there is a finding through evidence independent of the legal memos, of the legal emails, and of the indictment that there was a crime or a fraud, there is no finding. And at this moment, Your Honor, I understand you have the power to make that finding, but right now, no judge, and really the only judge I care about is you, and no judge, including Your Honor, has found that this stuff is subject to crime fraud. The last thing I wanted to say, Your Honor, and then I can answer any questions and sit down, is about work product protection. The state says it doesn't apply because it wasn't in anticipation of litigation. And that's just wrong. I mean, it's completely wrong. The November 19th memo or 18th memo specifically discusses a strategy to be used in Wisconsin where there was pending litigation in order to preserve the campaign's rights under the ECA while that case was pending. The December 6th memo, which the state says they don't have, specifically and expressly says it applies only to states where there is a pending lawsuit, and specifically goes on to make clear that the advice was related to maintaining the campaign's rights pending outcome of that litigation. The December 9th memo specifically discusses the 6 states where there was pending litigation, calls those the quote 6 states in controversy, and then goes on to discuss the relevant law and rules in those specific states. And finally, the December 13th email memo from Mr. Chesbrough to Giuliani, another Trump attorney, specifically discusses litigation strategy, specifically discusses the pending ongoing litigation in the 6 contested states, including Georgia and Arizona, and cites 4 law review articles, and then specifically discusses the possibility of challenging the ECA in the Supreme Court on grounds of unconstitutionality. That is all, by definition, anticipation of litigation. It can't get any more anticipatory than that. So with that, Your Honor, unless you have any questions, I'll let my colleagues from the state address any concerns they have.
Thank you, Mr. Grubman.
Good afternoon, Your Honor. Donald Wakeford for the state. I suppose I'll begin at the end with the crime fraud exception, Your Honor. I think unless you have any objection to that, that's where I'll start. The burden on the state is not high. A prima facie showing is about as low as it is possible to go. So I understand that Mr. Grubman suggested that an admission by Mr. Chesbrough that he had lied or engaged in fraudulent activity would probably do the trick. We don't have to get anywhere close to that. All we have to do is provide some evidence that indicates there is something more than a baseless accusation of crime, fraud, or wrongdoing. We talked a little bit about where is a case that talks about what quantum of evidence or what requirements must be met in order to establish that prima facie case. And I apologize that this is not in our brief, but since it came up directly, I want to cite it to you now, Your Honor. That case is 757 F Sup 2nd, 1339. That's Tyndall v. H&S Homes LLC. That is from the Middle District of Georgia in 2011. It's a very useful case because it sort of looks at both federal and Georgia law with regard to attorney-client privilege, work product, disclosure, a whole host of issues related to the issues that are before the court today. Sort of talking about what each body of law says, how each of them sort of interact together. And we understand that the way Georgia courts have interpreted attorney-client privilege and work product borrows heavily from federal interpretations of the applicable principles.
Do you have a copy of that, or can I just get that site again?
Yes, of course. It is 757 F Sup 2nd, 1339. And specifically at pages 1351 to 52, there is a statement that the prima facie showing that the client was engaged in criminal or fraudulent conduct when he sought the advice of counsel, that he was planning such conduct when he sought the advice of counsel, or that he committed a crime of fraud subsequent to receiving the benefit of counsel's advice. Second, there must be a showing that the attorney's assistance was obtained in furtherance of the criminal or fraudulent activity or was closely related to it. So just looking at that as our guide, what we have here is advice, a whole suite of advice provided by the defendant, Mr. Chesbro, to a range of people across the country, including Georgia, as to exactly what actions they should take, providing documents drafted by the defendant himself, directing them how to use them, and then indicating how they will be used later. It also there is also evidence, which we'll get into that in a minute, but there's also evidence that obviously all of this was done at the defendant's direction, and that these false elector certificates were submitted to Congress and to several other bodies of authority, including federal courts, secretaries of state, et cetera, and of course the vice president. So if we're looking at whether a prima facie case has been made and what the defendant's involvement under that standard needs to be, we've already met it. It's already there, simply by reference to, as Your Honor stated, the January 6th report alone. What they did there was synthesize evidence taken from dozens of witnesses, some of it received in prime time on television, indicating exactly how this plan came together under sworn testimony and providing a synthesis of that information in a final report to the rest of the country. And I didn't mean to interrupt, Your Honor, there if you had a question.
No, so I would say, are you still asserting that you think the indictment alone is enough to establish a prima facie case?
Yes, the indictment alone is enough to establish a prima facie case because evidence was presented to a grand jury which returned a true bill of indictment. It's not just one indictment discussing this plot, Your Honor. There's also one in Washington, D.C., which has been pursued by the special prosecutor there, which specifically names a co-conspirator number 5 who engaged in the exact activities with which Mr. Chesbro is charged here in Georgia under this indictment. So there's actually 2 indictments that have been returned.
But I think the point we were exploring with defense counsel was, if you're not allowed to establish this by reference to the documents themselves, how do we know that the grand jury indictment was returned without doing that? Exactly that.
Well, are we talking about the legality of the indictment, or are we talking about
No, just
the admissibility?
how can we use the indictment itself as having satisfied that, since they would be allowed to look at these documents? There's no question about that, because I don't think the privilege or the other evidentiary issues would apply to a grand jury proceeding. So knowing that they're allowed to do that, how can we be confident that an indictment satisfies that requirement?
Could have been returned against Mr. Chesbro based on anything except
Exactly.
attorney-client communication.
Exactly.
Well, a lot of the documents which have been referenced here today are sort of went unmentioned by Mr. Grubman. And there's a lot of them which are exchanged between Mr. Chesbro and other attorneys or members of the Trump campaign. But there's also a lot which are sent to fraudulent electors in 6 different states who are not parties to, they're not represented by Mr. Chesbro.
I mean, and so that's what I'm essentially getting at, is if you can compile those and synthesize them in a way that meets your prima facie case, should we really be focusing on just the fact that you were able to get an indictment?
I see your
Or does that open up a whole other issue?
I think, well, first of all, I want to talk about the Goss case, which was cited by Mr. Grubman from 1935. What that case is talking about is not a grand jury indictment. It is talking about unfounded allegations of fraud or crime. All that case is really saying is you can't come in, yell fraud at opposing counsel, and then the court can open up their books and look at anything they did for their client. There has to be some evidence. So I just want to distinguish that first. But yes, if what Your Honor wants to see is something that isn't between Mr. Chesbro and his purported client, and I'll get to that issue in just a minute, the emails between himself and electors in all of these states right there, that's outside of any attorney-client privilege and would could have been properly considered by a grand jury or anyone, and would fall outside of sort of the restrictions placed on what the prima facie case can be based upon. But the reason I mentioned the January 6th report is that it also makes clear that there are actions by others that were influenced by the actions and theories of the defendant that demonstrated his involvement in the conspiracy that are not based solely upon his communications. I'm thinking specifically of the actions of, for example, Dr. John Eastman, who tried using arguments put forward by the defendant and in consultation with the defendant to persuade the Vice President of the United States to violate the Electoral Count Act on numerous occasions, something that has been testified to, as the January 6th committee has told us, by the Vice President's Chief of Staff and his counsel. So there is evidence outside of these mere documents which demonstrate that the defendant's activities the defendant participated in a crime or fraud when he created the documents at issue in this motion. Let me see here. I think it's also something worth remembering. There was a statement Mr. Grubbin made that no court has found that these documents were part of a crime or fraud, and that is not true. The December 13th email specifically, it's alternatively called an email or a memo, Your Honor, but the December 13th communication written by the defendant was specifically found to violate the crime fraud exception by Judge Carter in California, a decision which was affirmed by the Ninth Circuit and which was Mr. Eastman vigorously appealed. His petition for certiorari was denied last week by the Supreme Court, declining to take the opportunity to look at this issue. So with at least one document, there's already sort of been an examination of whether crime fraud applies. The January 1st document is really just a recapitulation of what is stated in the December 13th document. It, as Judge Carter characterized that document, January 1st is also a step-by-step plan outlining what the defendant proposed people do in Congress. First of all, not an anticipation of litigation, but a political plan which discusses what kind of cover the vice president or related parties could take politically, what kind of steps could be done to leverage their position, and which outlines or which focuses on the fundamental goal of those in Congress who did not want to see Joseph Biden elected president, which is to deny him the number of electoral votes he needed on January 6th to become the president. So the January 1st and December 13th documents are extremely closely related in language, in theme, in ideas, and in the way they're presented. And one of them has already been found to violate the crime fraud exception. I don't think we can get away from that. The other two documents, the November 18th and December 9th documents, the November 18th document was not found to not violate the crime fraud exception. It was simply found to have already been disclosed. This is again, Judge Carter in California. It had already been disclosed to the news media, and therefore the judge found there's nothing to argue about here. It's in the open. There's no protection that can still be brought. So he never reached the question of whether crime fraud applied to it because he found it had already been disclosed and was not subject to protection on other grounds.
So what about the counter argument you just heard that unless it's an authorized waiver on behalf of the campaign, that doesn't count?
The question of whether the actions of the defendant himself constitute waiver is something that Your Honor should consider. We understand that if an attorney takes actions and makes disclosures which make it likely that something is going to fall in the hands of someone who is not his client, or actually do disclose them to someone who is not his client, then obviously attorney-client privilege is waived. With the November 18th memo and the December 9th memo both, as we've stated, they were provided to fake electors in a host of different states who were not the defendant's clients. They were outside of any attorney-client relationship.
But as I remember that the California opinion doesn't always explicitly lay out how they got into other people's hands. And unless we establish that, I wonder if we can so confidently say that it was waived. I mean, I think the point was made that that leaking is not a waiver.
Okay.
And
So
I would imagine that as a matter of policy, which is where we are with these privileges, there's some soundness to that.
well, there's the question of the leaking to the media, which happened on February 2nd of 2022. The November 18th memo and the December 9th memo were both leaked or showed up in a story on the New York Times. At that point, the January 6th committee had not started holding hearings. But anyway, it was leaked at that point. So there's that question. But those two documents were also contained in emails sent at the behest of Rudy Giuliani and the Trump campaign by the defendant to David Schaefer. And I'm not going to go through the names, but people in Pennsylvania, in Wisconsin, in New Mexico, saying, here are my memos take a look at them. Here's what you should do. Here are documents I'm attaching. This is what you should do based on the theories contained in my memos. So attorney-client privilege for those documents is obliterated by the defendant's own actions, which he took at the behest of his client, supposed client, the campaign. I'll get to that again in just a second. For the purposes of attorney-client privilege, that's clearly not applicable. There's also the fact that the defendant was using these memos as a sales pitch. The emails which contain them made constant reference to, we're trying to make sure everybody gets together on December 14th. We're trying to make sure all the electors in these states meet. Where the Mayor Giuliani is trying to make sure everybody gets together. We're trying. Here's why we think it's important. Here's why we think you should do it. He was sending this to people who weren't just not his clients. They were people who were not necessarily going to buy into this plan. Anyone who received these memos could have turned around and said, I'm not doing this. And we know for a fact here in Georgia and elsewhere, there were electors who said, I'm not participating in this. Every time the defendant took the affirmative step of sending this to someone who was not his client, was outside the attorney-client relationship, and who wasn't even a committed participant in any kind of plan, there was running the risk of disclosure by any one of those people, because it was sent to dozens, or pardon me, not dozens, but half a dozen different states with multiple people on each email as it was sent out. Finally, so with regard to disclosure, I understand there is a policy question, Your Honor, but we're talking about the defendant's own actions here in disclosing these things to people who are outside of any purported attorney-client relationship, and to people who had no reason to respect any kind of attorney-client privilege or work product privilege that he had with his client. These people were simply differently positioned. And we see that Mr. Schaefer provided these documents affirmatively to the January 6th committee and to the state of Georgia because he had them, because the defendant had provided them directly to him. So we're talking ultimately not about a policy of what other people may have done, but what the actions that the defendant himself took in sending these things out. And that's especially important with regard to the November 18th and December 9th memoranda. I do think I should address one thing, which is that with regard to whether there's an attorney-client relationship between the defendant and anyone, all that we were saying was that now that this claim has been raised as part of a motion to exclude, one of the only requirements for the defendant to start is just to demonstrate the existence of an attorney-client privilege.
So how does one do that? I think in your reply, you say, well, he hasn't produced a retainer or an employment agreement. Do you have, but that St. Simon's case that you cite just talks about a genuine relationship. It doesn't really say with specificity how you go about doing that. There may be other ways of doing it other than an engagement letter. The point is that nothing was done. There was just the assumption that was made. So we were simply saying, all right, if we're going to start at the beginning is we determine whether there's a relationship that can be analyzed. And the person who does that is the person claiming the privilege. That was not done. The reason it's important is that ultimately we need to know exactly who the client is so that we can examine what the parameters of the relationship are. If the client is the Trump campaign, that obviously means certain people are arguably going to fall within the attorney-client relationship. If the client is anyone engaged in litigation in Georgia, such as David Schaefer, that obviously changes things quite a bit. If the client was only the Trump campaign in Wisconsin, that changes everything. Because once Mr. Chesbrough starts volunteering his services outside the state of Wisconsin, how can he argue now that he is still pursuing his attorney-client? He's still pursuing his actions under an attorney-client privilege when his client is confined to one state. We don't know what characterizes the relationship. And without any evidence whatsoever, the court, I think, should take this under account. This exclusion, while of course important and a bedrock of our profession, I don't need to tell you that, is also strictly construed because it keeps evidence out of the jury's hands. It keeps evidence away from those who are charged with determining the truth and finding facts. So where a defendant comes forward and says that it applies, he should make a demonstration as to why and how, so that this court can engage in the actual inquiry which the defendant is asking the court to do. And how would that look? How would that satisfy you? An affidavit, a proffer, an evidentiary hearing?
Certainly not an evidentiary hearing, Your Honor, but something. An affidavit from someone saying that this is what this was my attorney. A piece of documentation from anywhere indicating what the range of the attorney-client relationship was. I'm not asking to be satisfied. I'm asking for something to be done because there has just simply been the assumption that this is satisfied. Certainly there is the appearance of an attorney-client relationship. We're not disputing there is the appearance of one, but the whole question is who was the client and what was that relationship and what set it out? That if the defendant comes forward and asks for protection and doesn't say as to whom or as to what range of activities, then it puts everybody on their back foot trying to understand exactly what protection should even be considered. But I don't want to get bogged down in that any more than we have to, except to clarify what our position on it is, because I understand we've talked a little bit about it. I think that with regard to crime fraud here, there is an indictment that has been returned. And Mr. Grubman pointed out that we are in a situation that is extremely unusual, and we have a moment of agreement on that. This is incredibly unusual. We are not trying to determine whether certain documents should be disclosed in discovery. We are not determining whether the court should look at something in camera to further the inquiry here. We're not talking about vague allegations of wrongdoing. We are talking about a returned true bill of indictment laying out precisely how the actions of the defendant in crafting certain documents participated in an ongoing criminal conspiracy, which was not complete before he took the actions that he did, but was actually ongoing and furthered directly because of the actions of the defendant. We are in a very unusual place, and almost no case that we're going to look at is going to have quite the same posture here. But in so doing, the Goss case itself, which was cited by Mr. Grubman, just says it just can't be a baseless allegation. There has to be something to it. There has to be some evidence which bears it out. Where the defendant is already under indictment, where the defendant is already under indictment here and is an unindicted co-conspirator in another proceeding in another jurisdiction for the same behavior, where there is already a multiple 100-page report by a congressional committee laying out the specifics of how this plan was carried out across the country with the defendant's participation and the participation of those who were affected by the defendant and his theories and decisions, where all of that is before the court and where the state is prepared to demonstrate to the court, provide to the court emails which are outside of any attorney-client relationship, demonstrating exactly what the defendant did and how it was related to a crime or fraud. The prima facie case has simply been met. And if Your Honor has any other questions about that particular point, I can answer them now.
So the state would be, I guess, incorporating as part of its argument the entirety of the January 6th committee report?
Well, Your Honor, yes.
All right.
Absolutely. Where you're asked to make a prima facie determination, and you said that what's to stop the state from getting up and saying this is what we propose our case is going to show, and there is already a detailed document containing sworn statements and testimony and other evidence demonstrating exactly what parts of this conspiracy looked like, then I think I'd be foolish to get up here and say we don't want Your Honor to look at it. Certainly.
But there aren't any aspects of that you're saying, I guess, are out of bounds or that you wouldn't be prepared to prove if necessary in the case in chief?
I think I don't think in trying to demonstrate to Your Honor that a prima facie evidence exists, that we are tying ourselves to the entire report and saying our case in chief is going to be the 800-page congressional report.
Sure.
I think what we are saying is that we just have to show you evidence outside of these communications, or just if what Your Honor is asking me is to point to something other than the indictment. That's what Your Honor said. I still think the indictment is enough. But if you're asking me to point to something else, I think an obvious place to point is that, especially specifically when it comes to the actions of the defendant and where Your Honor can determine whether a prima facie case exists. I'll also say again that it's an awkward posture here, as Mr. Grubman acknowledged, where most of these documents have been disclosed publicly, whether in the January 6th report, in the news media, or elsewhere. We provided the ones referenced in the indictment in our filing. We're dinged a little bit by Mr. Grubman for doing that. They've already disclosed. I mean, they've already out there, but I am hesitant now to enter, say, in this proceeding in open court, evidence which we say would meet the prima facie case, because evidently the defendant wants to be very careful about how we do that. If that's the way he wants to do it, that's fine. We can submit in camera evidence demonstrating that there are communications outside of an attorney-client relationship, demonstrating the defendant's involvement in a fraudulent scheme, namely the scheme to have people hold themselves out as the properly elected electors from the state of Georgia when they actually were not. The court has likely seen these emails. Lots of people have likely seen these emails because, again, they've been disclosed. But I would draw your Honor's attention to those simply standing in my place now as another example of how the prima facie case can be met for the crime fraud exception.
All right. Thank you, Mr. Wakeford. Mr. Grubman, any last thoughts?
Rebuttal, Your Honor, just a few points. Thank you.
I'm sorry, pardon me. I guess, Your Honor, one thing I want to be clear about is because of the procedural awkwardness that I just acknowledged, I'm not standing here saying I don't want to do my job and give you what you need. And so that later the court determines, well, the state had the opportunity to give
No, I
me this.
understand.
So
I'm just trying to think through still, and I'll need to look at it more closely. Just what it takes to prove a prima facie case, what our rules of evidence require, and the quality of the evidence that has to come forth. So
And the state, I just ask that we be given the opportunity to address any concerns that Your Honor may have,
understood.
given the awkwardness.
Understood.
Thank you,
Okay,
Judge.
Mr. Grubman.
With all due respect to my colleagues on the other side of the aisle, that was extremely circular reasoning. The reasoning was, why is it a crime fraud? Because we accused them of one. And that is what I understand. The way prosecutors accuse people in this state is a grand jury. But that is the definition of an accusation. A prosecutor is not allowed to accuse someone of a felony crime without going through the grand jury unless the defendant waives that. So by citing the indictment, what Mr. Wakeford is doing is saying our accusations, which is all when, in fact, Your Honor, when the jury is seated here and they read the indictment or a summary of it, what's Your Honor going to say? He's going to say the indictment is simply an accusation. That's the definition of it. And you know what, Your Honor? There is another one in DC, and it's been reported in news media. Mr. Chesbrough is UCC 5. But if an indictment isn't sufficient to prove crime fraud, then there could be one indictment or 5,000 indictments, and the number doesn't matter. All of them are accusations. Accusations are not evidence, thank God, in Fulton County or in the United States of America. The January 6th report is an accusation. It might as well be an indictment. You know, it's not a criminal indictment, but it has the same nature of one. It's not evidence of anything. For example, could Mr. Wakeford stand up in court and say, Your Honor, I'd like to submit the January 6th report as evidence to the jury? Of course not. Your Honor would say, that's not admissible evidence. That's an accusation. Those are all accusations. Now, to talk about the case that they cite, I didn't get the name, but the Middle District, Georgia 2011 case, we looked it up. In that case, the court made a finding of crime fraud after an in-camera review of the documents in question. And so to the extent, as I said, kind of half tongue in cheek, but honestly, there's, half not tongue in cheek, unless Your Honor believes that we have satisfied our burden simply here and in the motions, at minimum, before denying our motion, I think even the state's case says that you would need to look at these documents in camera. Again, the reasoning is simply circular. Why and I'm really, Mr. Wakeford did, I'm sure, the best job he can do given the circumstances, just like sometimes I have to do given the circumstances. But the bottom line is the state's argument is simple, is the following. Why do we meet crime fraud, judge? Because it's a crime. That's what they said. Why do we meet crime fraud? Because that man committed a crime. Well, thank God that there's no one in this courtroom, including, with all due respect, the judge, who can accuse that man of committing a crime without evidence. And that is what they stood up here and said over and over. Judge Carter may have, I would have to study that. Judge Carter may have found that the December 13th memo was subject to crime fraud. With all due respect to Judge Carter, he ain't my judge. To the extent Judge Carter found that any of these documents are subject to crime fraud, we disagree with Judge Carter, and we would ask this court to find otherwise. To the extent that the state argues that Mr. Chesbro or other folks waived attorney-client privilege by sending these documents to folks like David Schaefer, I would cite, amongst other cases, and I could submit this later if the court likes, we just found it on Westlaw, Newman, and that's spelled Neuman, v. State, 297 Georgia 501 from 2015, which specifically, it was overruled on other grounds. So there is a red flag, but not on that ground. And it specifically said, in fact, I'm going to take out my phone if that's okay, because Mr. Wilson texted me the screenshot. It said, quote, "It has long been the law of Georgia, in keeping with the other United States jurisdictions, that the attorney-client privilege includes by necessity the network of agents and employees of both the attorney and client, acting under the direction of their respective principals." Now, we would argue, Your Honor, and this is a whole nother issue, and we could submit further briefing because it kind of just came up in the reply brief, but we would argue that Mr. Schaefer and them were acting as agents of the Trump campaign at that time. That case law makes it clear, and I'm sure there's other case law out there, that case law makes it clear you don't have to be an employee. You have to be someone who's acting on behalf of an entity for some purpose. And Judge, I'm sorry, but I find it a bit disingenuous if the state stands up and says, well, Mr. Schaefer wasn't acting on behalf of the Trump campaign for a common purpose. And the reason I would find that a bit disingenuous is because quite literally, the entire case that the state has brought is premised on the idea that Mr. Schaefer and these other quote unquote fake electors, which of course, Your Honor, we completely disagree with that characterization. There's nothing fake about them. But their whole case is premised on these fake electors. Remember, David Schaefer is a defendant in this case. And the reason I think that's important is because it shows the state's theory that I'm not saying this is true, but the allegation is that David Schaefer, was acting on behalf of the Trump campaign as what they call a fake elector. Well, you can't have it both ways. If he was acting on behalf of the Trump campaign, and that goes for all the other folks all around the country, only reason the state didn't indict them is because they don't have jurisdiction. But if David Schaefer is allegedly acting on behalf of the Trump campaign in his role as a Republican elector, well, then he's an agent of the Trump campaign for that purpose. And under Newman v. State, there is no waiver. And the last thing I will say, Judge, is I misspoke slightly. While there is no engagement letter, and that's kind of the way I view it, because, in my practice, certainly best practices are to have a letter signed, laying out. There is an email that we could submit in camera that was actually submitted to the DOJ when this same issue came up from between Judge Trupis and Mr. Chesbro that I will represent, I believe will be sufficient for the court to find that there was an attorney-client relationship. And then lastly, the state's argument that, well, that was about Wisconsin. I can also submit one or multiple emails to you where the Trump campaign reaches out to Mr. Chesbro and says, can you expand your research to the other states where there's pending litigation? And so that argument's somewhat dead in the water before it even really had a chance to breathe any life. With that, Your Honor, I really appreciate your time. And unless the court has any questions, that's all we have. One moment, Your Honor, I think. All right now. Thank you.
All right, so let's do this to supplement some of the things that have come up as a result of the hearing. Mr. Grubman, if you could submit in camera, I believe this would also be ex parte, but the emails you just referenced that will, in your opinion, establish and document the existence and nature of the attorney-client relationship. And then if you could also submit, if you have them, the 5 identified challenge documents that you referenced. And then we'll make these, I'll file these under seal once I've received them from you to have them as part of the record. And the state, if also you referenced wanting to do this in camera, if you'd like to do a supplemental response that shows without reference to any of the legal documents that are being challenged why the prima facie case it exists here, certainly you can do that, and we'll have that as part of the same sealed filing. It could simply be a bullet list. Here are the facts that we contend we're going to introduce at the trial. Here's why we think it shows that the crime that was committed out of his documents. And I'll take a look at those and see if the standard has been met. So that leaves us with, I think both sides had requested maybe some preliminary conversations about the jury questionnaire. I received those from both sides, and I certainly I've looked through them, and on the face, I would say that we would start with the defense's version as the working copy. I just think it's kind of better organized and put together. So I think on the front end, what I would ask is I've already incorporated, excuse me, can we go off the record on this, or do we need to be on the record to discuss the jury questionnaire? Okay, I always try to spare Ms. Smith.
We would prefer stay on.
That's fine. Okay, so I've already incorporated some changes as requested by jury services, so I'll send that working copy, CCU, to the state, and then I would ask the state to incorporate in the format with the boxes and the yes or no, so that we're all working off the same collective document. And then from there, we can start going through it in more detail. But on the front end, I'll just, if you need more time to look at it, we can take it up either tomorrow or at some other point, probably this week. But were there any initial reactions or objections on either side to what is in the questionnaire? And I'd start with the state. Okay. And again, this isn't a speak now or forever hold your peace kind of situation, but we do need to get this over to jury services. My goal was by Friday so they could start making all the copies that they need to make.
I hope it's okay if both of us say something. Generally, I'm just going to note this. I know this is going to be a combined document, Your Honor, but I think it's a serious issue, and I'm not trying to point fingers or anything, but my reading of the state's submission was essentially there was one question, and it was worded slightly different, but essentially my read was, are you a Republican? That's the state's submission. Are you a Republican? And while that might be a moot point, it's not those exact words, but clearly that's what they're asking. They have nothing about any other political party. They simply say, did you volunteer for the Republican Party? And what that shows to me is that that's what this case is about. They're going to try to get all the people off the jury who have ever, supported any sort of Republican causes, who have ever supported the Republican Party or voted Republican. I just want to put the court on note and the government on notice that we are going to challenge that, because this cannot.
Well, let's talk about,
I
I understand that's the theme you take away, but when we actually look at the specific questions, many of them were identical. You asked, just like the state, how would you characterize your politics? Very liberal, somewhat liberal, conservative. You say, what political party do you identify with? That's identical to what they're asking.
That's asking for which one.
Right.
I think that's completely different, Your Honor. It's different to say, we want to know this is a political case. So yes, we should all know what political party. What they ask is they don't even try to pretend. What they say is, are you a Republican? To me, that's inappropriate. Mr. Aurora has more specific objections. I just wanted to say I thought that was inappropriate. I think it shows the theme. This district attorney's office is trying to prosecute the Republican Party, and that's why we're here. And I think they admitted it in that submission. And it's not going to be, the reason I say that now is because it's not going to be clear for the record later, because we're going to combine it.
Well, to that end, my thought was once we do have a consolidated final version, I would file an Exhibit A and Exhibit B.
Yes,
And so both requests, and it would be clear which ones were stricken or denied. All that'll be clear on the record.
yes, sir.
Okay, noting the general concerns, though, I think the only way to actually get through this is to focus on specific questions. And if we think that they shouldn't be on the questionnaire, so that's going to be the theme here. I think both questionnaires as submitted. I think it's unavoidable that it's going to be an abundance of inquiry into each juror's political inclinations. I don't see any way around that in some respects, but there will be some curtailing here as we sort through it. But as I'm doing that, I just wanted to give everyone an opportunity here to in addition to what Mr. Grubman mentioned, if there were any specific other questions or themes that you think I should be alert to.
I think we'll just wait since you're gonna submit both as exhibits. That way, any objections are obviously noted as far as that goes. My question to the court is, are we gonna be able to get the names of the 450, like the little biographical stuff we do, so we're not trying to get it all done over the weekend with a relatively long questionnaire, just so we have enough time to really digest what we're talking
Sure. So again, more kind of the logistics of what we have planned. If you've tried a case here in Fulton, you know that a lot of times they'll give you this little biographical packet with the basics of, who's your spouse, where are you employed, what part of the county you live in. That is actually all manually entered by each of the jurors as they show up. And so what I saw in the questionnaire provided by the defense is all those questions are actually laid out here as well. So to have them answer this questionnaire and then show up and get that traditional packet that we use in Fulton County, to me seemed redundant, and it also kind of duplicative of services. So in terms of when you ask about the bio information, that's going to be from the questionnaire. So your other point was, how are you going to get this questionnaire and how far in advance? We've talked about the shared drive that everyone's going to have. As they're scanned and uploaded, everyone's going to have access to them. I think I've asked you all to give me the email addresses of who you want to have that. So I'll keep an eye out for that. And then in terms of Friday, the plan is to have it at a minimum, the first 30 in there. And then from there, it's going to be as jury services is able to scan them in. I would anticipate they're going to be at least a day or two ahead, if not more so. They may have all the initial 450 done by Wednesday of the following week. But at a minimum, you're going to have the next days by the day before. That's the promise.
Are we doing 450 on the 20th in that big room, or are we gonna meet with different groups?
No, it's just a 450 in the questionnaire on the 20th.
That's fine. And the reason I'd asked about the bio is, I just got called from jury duty last week, and it made me fill something out online. So I thought maybe I had it in advance.
So apparently only 20% of people do that. And so noting that the other 80% do not, what's in this questionnaire is going to satisfy that for us.
Going back to the Supremacy Clause, I think on September 27th, one of our co-defendants had made a motion that added some things that adopted it. I just want to make sure if the court can look at that too, to maybe possibly answer some of your questions. There's a brief filed. Who filed it on the 27th? Schaefer's counsel had filed it.
Had adopted your motion, added other things.
It's a clean bar, and it was filed on September 27th. I know you keep numbering the docs, but when I look at it, I don't know how to number it.
It's not showing the numbers for you?
No, sir, it just comes in by date, so I have no idea.
Right.
what
Okay.
you're talking about.
I'll see if I can get to the bottom of that. That's something that was just a feature that was added recently. And the intention was for everyone to be able to see that.
I think that's all I have until tomorrow.
Okay. All right. So again, like I said, what I'll send to the state today is not the final determination of what I think should come in or come out. It's simply, I want the state to add in theirs in that format, send it back to me. And then I'll start trying to go through it and applying the questions that I believe are appropriate and lawful. But I still want to give everyone the opportunity to see what that final draft looks like and the ability to object, and maybe things will go back into it based on what you say. So when we're able to do that, we'll see how quickly we can get this together. I think we'd already blocked out Monday, Tuesday, Thursday, or Monday, Tuesday, Wednesday next week if we need to schedule more hearings and that sort of thing. Okay, but nothing else I'm seeing about the questionnaire. Anything else? Okay.
We also probably need to go through the indictment and like we talked about, which counts are gonna be read, just so we can have that done and not at the last minute. It's a big indictment and how you summarize it, I guess.
Okay, I'll let you take that up with the state and you can report back to me on your progress. Anything else? All right, we'll be back.
One thing.
Sure, always one thing.
Sorry, I know that you entered an order in regards to the state's notice of disqualification of certain, well, specifically Mr. Grubman.
Right.
There were some things that were presented to the court in camera. The only thing that the state would be asking is, I don't know if that included a waiver from Mr. Chesborough, but the state believes that needs to be part of the record. Either they're going to submit it in camera under seal, but that does need to be a part of the record.
Sure. So all the documents provided to me by Mr. Grubman have already been made part of the record and under seal. All right. Anything else? Okay. Thank you all. See you tomorrow afternoon.